Ashish sir, are you started? Ashish sir, are you here?
Ma'am, just give him a second. He's trying to connect to the web.
Hmm. Good evening, sir. I'm audible.
Yes,
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 sir,
sir.
you are audible.
You're audible.
Good afternoon, Mr. Ashish ji.
Good afternoon, sir. How are you, sir?
Good.
Yeah. So this is a roundtable conference on the discussion paper on issues related with on the real estates. So we all have to put our views on the all the issues proposed in the discussion paper.
Sure, that's why we are here.
Yes. So I'm the moderator. So we are starting with this discussion papers one by taking issue one by one.
ये भाई सब
So
नमस्कार
my request will be, sir, if anybody is putting
ठीक
their
ठाक आप
views,
बताइए
he has to give their name because we can note down the name
क्या
of the
हुआ
IP and we can note their views. So if anyone is
अरे नहीं
giving their
क्या
views,
बात है आप
they
ऐसी
has to
बातें करो
mention
आपको
their
भी
एक
याद
name.
करने की
मिनट
जरूरत
सर,
पड़ती है
there is a sound. Mr. Prabhakar, please mute yourself. Mr. Prabhakar, please mute
नहीं
yourself.
और बताइए
प्रभाकर जी, अपनी आवाज बंद कर लीजिए।
पुष्पांजलि में कहाँ पढ़
कमाल हो गया।
Prabhakar ji,
अ,
all are requested to
अच्छा
mute themselves. Anjali ma'am, if you are there, then please mute all the participants.
ठीक है आता हूँ
I don't have the
तो वहां
right
वाला
to.
चेंज कर दिया क्या
अंजलि जी, are you there?
अच्छा बहुत बढ़िया फिर
Yes, sir, I am here.
Can you mute Mr. Prabhakar and can you also
Yes,
make me as a co-host so that I can mute in case of disturbance?
Please make
जेंडर में क्या मतलब इम्पैनलमेंट अभी हुआ नहीं है आपका
Please make me co-host also, madam.
अरे कई बार तो बोला आप बना कर तो
now we can start. Now
Yes,
we
yes.
can start.
So all these proposed amendments are with respect to the real estate sectors. Let me introduce myself. I'm Ashish Singh. So I'm doing currently four matters assignments which are related with the real estates. In three assignments, the resolution plan was has been before the NCLT, and one is going on, for which I had issued the separate Form G for the two separate projects in the real estate sector. So my request will be that if anyone, all are requested, all are welcome to put their views, but before putting their views, they have to mention their name so that we can note down the name of the IPs. So we are starting with the issue number one, which is that the proposed inclusion of the land authorities in the committee of creditors meeting. So I'm just reading out what the issue is mentioned in this discussion paper and what the proposal is. Thereafter, we will start our discussion. The issue is in the CRP involving the real estate companies. Land authorities play a crucial role but currently lack mandatory representation in the committee of creditors. At present, the financial creditors are included in the COC, while land authority, generally being the operational creditors, are not. The absence may lead to the insufficient consideration of the land authorities' perspectives on the land-related issues and the regulatory requirements, potentially causing delay or complications in the implementation of the resolution plan due to unforeseen challenges. Moreover, valuable inputs from the land authorities that could enhance the viability and the feasibility of the resolution plan is often missed, reducing the coordination between the insolvency proceedings and the land-related matters. Then given the significance of the land assets and the associated regulatory compliances in the real estate projects, there is a clear need to ensure that the land authorities have a formal channel to provide input during the CRP, while maintaining the decision-making authority of the financial creditors. The report of the study group constituted by the IIIPI also advocated for suitable representation of the land authorities in the Committee of Creditors. The proposal is, sir, the proposed amendment would mandate the inclusion of competent authorities as invitees to COC meetings in cases involving real estate companies without voting rights. This would be achieved by adding a new sub-regulation to Regulation 18, requiring the resolution professional to invite as competent authorities as defined in the Real Estate Regulation Act 2016 to attend COC meetings as special invitees without voting rights. By providing competent authorities, including the landowning authorities, with the opportunity to offer input and raise concerns during the CRP, while preserving the decision-making authority of the COC, the proposed changes address a significant issue in the regulatory framework. From a stakeholder perspective, the presence of such competent authorities in COC meeting can enhance the transparency and build confidence among home buyers and other stakeholders in the resolution process. So, sir, in this proposed amendment, so they are mentioning that there are certain benefits, like the land authorities can have a sufficient consideration on the land related issues and the regulatory requirements. So I will welcome all to put your views one by one by raising your hands. I will ask the participants uh, by name, and they can put their views. So you can unmute and you can put your views, sir.
Uh, Myself, Ajay Kumar Chen, I'm IP and advocate also. Can you clarify about the land authority? Land authorities, should I say DTCP, Noida, etc.?
So land authorities has been defined. They are saying that competent authority as defined in the Real Estate Regulation Act 2016, and the competent authority has been defined in RERA in section 2, subsection P, which says that the competent authority means the local authority or any authority created or established under any law for the time being in force by the appropriate government, which exercises authority over land under its jurisdiction and has
Yes, yes,
power to give permission for the
I
development
got
of
it.
such immovable
So it's
properties.
the
Yeah,
local authority, that is Noida, DTCP, etc.
correct, correct, correct.
So see, if land is leasehold land, then
Yes,
if it is leasehold land, then definitely we must include Noida authority or land authorities in the COC meeting, because in leasehold land, title does not transfer in favor of the buyer. So the lessor always keep the ownership of the land. Say, Noida authority gives land to the builder for 99 years. What will happen after 99 years? So that should be this land authority must be part of the COC, so that he can give his consent, whether it can become freehold, or what will be the next course of action after approval of resolution or after expiry of 99 years.
correct. Yes, sir. So we can also get a information about the status of the land. Like if there is a project, what is the status of the license? Whether the license is valid or license has been expired. Because now we are seeing that this is not for the proposal, but now we are seeing that many IPs are receiving notices that they are starting the construction as per the as pool and bill. Now I have the information that the IBBI issuing notice to IPs saying that you have commenced the construction and your license has been expired. You are not allowed to commence the construction, and you should be registered with the RERA.
See,
Therefore,
Ashish, the construction is a very small thing. I will tell you the very vital example where this law has been ignored. That is in the case of JNC construction, the Supreme Court has turned down the entire resolution plan, which was approved 3 years back, and the entire process came to halt and it squared to zero. So resolution plan is approved by the NCLT, thereafter enclate also, and thereafter the management has been taken over by the RA, and construction has been also finished 99%. Now Supreme Court has rejected the resolution plan. The Supreme Court says that the landowners, that is Noida Authority, who is having X amount claim, why he was not included in the COC? Why his consent was not taken in the COC? So back to nil. So entire process back to zero.
yes. So Rajesh Shah ji wants to say something. Rajesh Shah ji, please speak.
Yeah. Yes, sir. See, the point is, we are telling all this is fine, but what authority we have that they will give or they would be helpful? Because the point is, if you are just making it a point that they are going to be there, whether they have
Yes.
authority or they are going to exercise their authority and give you anything, otherwise it's just going to increase your complaint. Nothing is going to work unless the order is there. That is my view.
So, my opinion is that when we become the IRP or the RP of any real estate company, we don't know the status of the real estate, like the land.
Yeah.
I think the plus point will be that if we real estate authority or the competent authority is the part of the COC, then we can have the first-hand information from them. What is the status of the land? And
Correct.
it will be helpful in the building this information memorandum and everything. And the
Correct.
COC
Correct.
can take a best decision what to do with this corporate debtor.
See, there will
Intention
be
is perfect. Intention
I
is
will-
not the issue. The issue is
Yes.
whether how to do it.
see
Because they
let
don't have
me-
any voting right. They don't have anything.
see,
They are just going to come.
just a moment. Rajesh ji,
Ajay
what
ji,
happened? Ashish ji, I'm sorry for intervention.
My
Yeah,
point also,
I'm fine.
I am agreeing with the Rajesh ji with this point that like in the banks, in the financial creditors, some authority represents the bank and they don't have the decision-making powers. If Noida authority sends some junior level, junior officer, they don't have the decision-making power. I think the Rajesh ji want to say that what uh, uh, they can do, positive thing they can do for the COC.
Exactly.
I'll tell you because I have faced the practical problem in this situation. What happened? Promoters suppress many things. What is the dues? What dues to the land authorities, etc. Second thing, IRP chase pillar to post to the land authorities for getting the clearance or getting the dues, etc. Everything, but they delayed all these proceeding while giving the information. If we make land authority a party in the COC, a member of the COC, even if without voting rights, at least we will have clear picture. We will not have to chase to the land authority, and we will save the plenty of times, major time of CIRP.
Ajay ji, what we are telling
You know,
is that they
Rajesh
are
sir,
telling-
the main
Hello.
benefit is when the authority files a claim.
Sir,
We have
Shyam
seen
ji,
in
please mention your name so that we can write your views.
you have said my name, no?
I said your name, but
Okay,
it will be better because
okay.
there are many persons. I
All
may not
right, all right. I'm Shyam Arora. I'm also IP and advocate. And my point is, we all have seen when an authority files a claim, it is always an inflated claim. You know, the benefit of including
True.
these authorities in the COC is primarily IRP can have a definitive figure by liaising with the authorities कि जितने inflation हो रखा है वो क्यों हो रखा है, and to correct the claim at the interim stage. I think this is the benefit.
The other COC member will also be like there will be transparent because this other COC member will also be agree or disagree with the presentation of the land authority.
प्रेजेंटली तो सर देखो आईआरपी ने क्लेम पहले डिसाइड करना है, उसका क्लेम नहीं डिसाइड होता, उसका कितना है वो वही लेके वो अथॉरिटी वहां पे एनसीएलटी पहुंच जाता है, जी मेरा क्लेम ये है, हम पहुंच जाते हैं नहीं, इनका क्लेम ये नहीं बनता.
Correct. It will
This is
reduce the
also a point of
litigation.
litigation. Yes.
Correct. It will reduce the litigation time.
And other point is, we all send the notice to the authorities, but they don't come.
Correct.
They always prefer to go to the NCLT in spite of coming to us.
Frankly,
So
for them,
this
what is there for
invitation,
them?
Rajesh sir, this invitation should be mandatory from the IBBI. Their presence should be mandatory.
See, if it is leasehold land, definitely, and if there is claim or not claim. If there is no claim without voting right,
I think this suggestion should be noted. That is most important is it should be mandatory for on the part of real estate authorities to attend the meeting. They should not take it lightly. I think we should note it down as the first suggestion.
correct. He will give the clear picture because promoters suppress many things. They do not disclose their
I think this has already been discussed that it will be beneficial.
Correct.
Everyone agrees on that.
Yes,
The main
yes.
point is how to make them mandatorily attend the meeting. So this suggestion number 1, in my opinion, should
Yes,
be
it
this
should be.
only.
It should be in the regulation itself.
Yes, and some
Correct.
provision should be there to make it compulsory for them.
Right.
If we want to discuss the what regulation 18 for which they are adding the new sub-regulation, I think we should know what regulation 18 is. So regulation 18 says regulation 18 is with respect to meeting of the committee. So they will add the sub-regulation, the regulation 18. So everyone is agreeing that the Noida authority should be part of the COC without the voting rights.
Land authorities.
Sorry, land
And-
authorities, competent authority.
Yes, yes.
And
Yes.
sir,
So,
I want
they
to
should
ask one input here.
yes.
I'm Darshan Patel, insolvency professional and a chartered accountant. So I'm concerned that what is the legislative intent behind these all that to have the authorities as a member of COC, that ultimately the decision of COC must be, the authorities must be convinced with the whatever plan or whatever the decisions are. I think that is very important. So when they are not convinced, what will be the output of the outcome of the whole COC meeting or a resolution plan? That is a question.
So even if they are not convinced, then it has to be approved by the committee of creditors. They don't have the voting rights.
Yeah. So what
It
is
will be
then
the-
what is correct? Then what is the intent behind these as a member of a COC? So I think the legislation is thinking that they should be convinced with the process or the resolution plan. That is something I think
I
so.
think, sir, as the Shams has said that they submit the inflated claims. So in many cases, I've seen that as per the books of the CD, the claim amount is say 100 rupees, or they claim 1000 rupees. This is the level of difference in the claim amount and the as per the books of the CD.
No, Ashish sir, one more thing. In my opinion, उनका account चलता है quarter के हिसाब से. And what they do, suppose my insolvency commencement date is 31st December. Yeah,
Yes.
you can say my ICD is 10th of January. And you know what they do? They prepare their claim up to 31st March next year. Or next quarter next year.
Right.
I've seen that.
Yeah.
And
Yes.
they are never agree to for the reduction of the claim amount of the claim.
In one of my cases, sir, the IDC, this DTCP, the competent authority has claimed the amount of rupees 22 CR, and as per the books of the CD and as per their own letter, just some months before the commencement of the CRP, they were asking for the dues of only 2 crores rupees. So this is a level of difference. So if we include this authorized person from the competent authority, we can at least negotiate this part, that why this
Moreover,
that
Darshan sir, I'll take the point of Darshan Singh ji. Darshan ji, see, if we invite the authorities into COC meeting and record it in the minutes also, जो भी वहाँ proceeding हुई है, at least we can have something to present before the NCLT.
My concern is that in that case, when the authorities are not agreeing what is being discussed or approved, then in that case, won't it be work as against the plan? Because NCLT will say that so and so authority has denied and they are not agreeing with the plan. So whether it is solving or whether what is the intent behind it?
See,
Normally what they do, Darshan sir, they come at the end of the process when you submit the resolution plan.
Correct.
And they come with the objections only. Objection on the resolution plan.
Correct.
So
Darshan ji on different points. I'm sorry for interrupting. Darshan ji is on different page. He is saying that what is the role and what is the locus? What is the locus of this authority to participate in the meeting? The locus will arise only. Locus with respect to voting right will arise only with respect to the claim. And for participation, he can just deliberate. He can just give deliberation about the status of the project, status of the land, dues of the project, etc. But if he has no claim, then he will have zero voting rights.
Correct.
If he crossed the threshold, that is 10%.
One more thing, Ajay sir. If the authority has not filed the claim, whether you will invite him?
Yes.
You know, this is also a different thing.
No, if
whether claim is filed or not,
he will be participating or as a zero voting right. With zero
not having voting rights.
Yeah.
Correct.
Sir, in that case, what will be the point of discussion with him?
Just to have the correct position of the land. What is the status of the land?
I think someone has already said that if at all there is likely to arise some objection in future, so that can be raised by the authority then and there itself.
Correct. They cannot back
so
out.
far as I understand, that is the main purpose of his presence in the meeting is. If, he knows the exact land rules and certain specifications connected to that local area.
Correct. They cannot
and
take.
He can give his inputs.
Sir,
That
this
is
Manoj
Agarwal
from Mumbai. I am IP.
I
will add one thing. This is not only the land authorities. There are other departments like BMC in Mumbai, Bombay Municipal Corporation. They are not a land authority. They are not the land authority, but still their claims are so big. So what is the use of including only land authority?
Please speak
They should also be invited. BMC like people, SRA like people, they should also be invited.
Sir,
Because in one case, in one of the big case, what I am saying is that what someone rightly said, that they have filed objection to the resolution plan at the end. So their claim was 200 crore. They made it 800 crore and filed the objection, and now they have filed the claim of 1300 crore. So all these things happens. So BMC, not a land authority. Why only land authority has been invited in this? So my suggestion is that not only land authority, any authority which is having a secured type of right or which can impact the resolution plan. That may be BMC, that may be any municipal corporation. Like they are saying that we have a charge on land because of rainbow judgment. So we are secured. So they are secured operational creditor. So they should also be invited.
If they see, as per new regulation, IRP is supposed to send email or letter to all this claimant, all these creditors to file a claim apart from publication of Form A. So in that case, if they file the claim, say BMC, yes, welcome, his claim will be admitted, whether he will be part of this COC or not, depending upon the claim amount. And if they do not file the claim, they are out. They cannot raise the letter on that we were not invited. Why should we invite? We have sent email, we have sent letter, speed post, we have published the notice Form A. Why you have not filed the claim?
Then Ajay sir, what about EPFO?
See, they had filed claim of 200
The
crore.
EPFO is
Then
very
they
active
filed
nowadays.
objection. Then they
EPFO तो कभी
filed
claim file
objection
करता ही
of
नहीं है.
800 crore. And now when the NCLT Mumbai has given them the right that they have rainbow rights and they are secured creditors, you will have to consider them at this stage also after resolution plan is approved by COC. That time also you will have to admit them. So they are now filing claim of 1300 crore, which is under negotiation. Some means all the claims are wrongs and all that is a different thing. But they should have come on the day one when the COC has been formed. If they are being invited, there the provisions should not only. My suggestion is not only to land authority. It should be कि जो भी any government authority which is having some sort of right which can impact the resolution plan.
See, Manoj,
Not only land authority.
Manoj, then I am sorry to intervene. Then there is GST. You should also invite it. Income tax.
No, let Ajay ji, let cut it short.
So
हमारे लिए एक अच्छा स्टेप है. हमारे लिए एक अच्छा स्टेप है कि लैंड अथॉरिटी को उन्होंने इंक्लूड कर दिया है. एंड लेट्स होप कि कल को बाकी जो सिक्योर्ड क्रेडिटर अपने आप को बता रहे हैं वो भी आ जाए सामने. उनके लिए भी IBBI रेगुलेशन लेके.
I think it is a prerogative of the RP to invite any person. If the RP needs any statutory authority to represent in the COC, he can invite them. But this proposed regulation with respect to the land authorities for the coming under.
Let's be limited to this land authority only now.
Yes, because there are many statutory authorities. It will not be possible to invite all the statutory authorities in the COC meeting. So I think
IBBI को लगता है वो ले आएंगे सामने.
No, it's not even practical.
So, but
भीड़ लगा देंगे सारी COC के अंदर ही. मैंने तो हम नहीं करना.
Rajesh Shaji want to say something.
Yes, sir. See, the point is we are talking everything what we want.
Yes.
Can we think from land authority perspective, that department perspective? Why should they come for each and every COC meet where there is nothing relevant to them except their own dues?
No, Rajesh ji, intent is throughout the process, RP is in dark. That what will happen to these claims of these authorities.
That is why he is not supporting us. See, understand? He is not there to serve us.
Sir, let it
And
be.
You cannot accept. Yes, we can think of it. Because why should he come on each and every meeting, whereas nothing is relevant to him? We are just thinking that we want it. That doesn't mean he will do it. This is my suggestion. I am fine with it.
See, it is not necessary that he should come in each and every meeting if the purpose of the IRP has been.
No, sir. Authority is referred as invitee.
Correct.
It's not कि भाई उसने कोई मीटिंग में एजेंडा नहीं है तब भी आ जाना है उसने. अब उसको इनवाइट करो कि उससे रिलेटेड एजेंडा है तो.
सर आप
नहीं.
That is absolutely right. I think only in the case of, say, resolution plan proceeding or something like that, in that case only they should be invited. So at least the scope should be limited to certain aspects only.
Sir, I think.
Sir, in that case, then we will have to share the resolution plan with them also. Can we share the resolution plan copies of all the resolution plans to these authorities?
So there are many other questions like that.
If his interest is involved, his claim is involved, definitely he is entitled.
I think we can take the advantage of these competent authorities in the COC only when we can invite them initially at the time of the commencement of the CRP. We can take maximum information from these competent authorities.
Yes, this is very relevant.
Yes. So everyone majorly is agreeing that this competent authority should be part of the COC.
With a limited scope, but I think with a limited scope.
And compulsory attendance.
Yeah, and compulsory attendance.
Okay. Pinakin Shah wants to say something. Hand is nikya. Okay. Now,
Sir, how will IBBI make it compulsory attendance for the other land authorities on which you are not?
Compulsory doesn't mean that in case of his absence, the meeting will be adjourned. he will be invited through notice. He present or not present, it is their choice.
Oh, somebody said compulsory attendance. That was
Compulsory, then meeting will be void. The meeting will be meeting will be adjourned. Compulsory means, so it should not be compulsory. It should be that the IRP must send notice to the land authorities that this is about the
Sir,
COC meeting.
just see the
that
practice,
means
sir. I tell you, just see the practice. Darshan, see, just see the practice. What happens? They never come to your COC.
yes.
Despite of your invitation or your mail to the authority.
Then meeting
They
will
come. They come only at the time of when the plan is passed or yet to be passed by
Arora
the
ji,
COC or NCLT.
absolutely,
Then what-
Arora ji,
then
and
what
that
will
is
be the
Arora ji, that is the intent, that then whenever you are invited to the meeting and if you are not attending it, it will be deemed that you are agreeing with the agenda. See,
Correct.
it does not mean that you are not attending and then after, say, a couple of months later, you are objecting everything. So that is the intent, that if you are not attending the meeting, RP has invited you, then, and if you are not attending the meeting, you have to, it is deemed that you have agreed.
Yes.
That should be the logic.
Yes, because you are sending all the agenda to him minutes also. Right. ठीक है आशीष जी, आगे बढ़ते हैं.
So there should be specific regulation that his right will be forfeited, subsequent right, in case of
ये whether it will be possible. चलिए, anyways.
That will not be feasible.
Then if meeting,
Then we are concluding that they should be invited in the COC meetings. Competent authorities should be invited in the COC meetings, and we are agreeing with this proposal.
Yeah.
Issue number
You have
two is
you have to note down any suggestion also, no? You have to give
we have
suggestion
noted
also.
suggestion. We sent a detailed suggestions with the conclusion that we are agreeing with this proposal.
Okay.
Issue number two is the handling cancelled land allotments in real estate insolvency cases. So issue, I'm reading out the issue. The triple IPI reports noted issues related to cancellation of land lease or the allotment in case involving real estate corporate debtors. In this regard, there have been instances where the allotment of land has been cancelled and possession has been taken back by the authorities before the insolvency commencement date. The situation creates uncertainty in the CRP as a primary asset of the CD may no longer be available. Currently, there is no specific provision in the IBC or the CRP regulations to address this issue. It is proposed to amend the CRP regulations to include a provision requiring the insolvency professional to report to the COC and the adjudicating authority when land allotment has been cancelled and possession taken back by authorities before the insolvency commencement date in real estate insolvency cases. This crucial information will enable the COC to make an informed decision on alternatives such as withdrawal, early liquidation, dissolution, or the continuation of the CRP. The proposed amendment aligns with the spirit of the Regulation 40D of the CRP regulations, which outlines factors for the committee to consider when contemplating liquidation of the CD. These factors include non-operational status, obsolescence of goods or services, absence of assets, lack of intangible assets, other elements that may affect the entity's value as a going concern. By ensuring timely reporting of land allotment cancellations, the COC will be better equipped to assess the viability of the real estate projects and make decisions that best serves the interests of all stakeholders involved in the insolvency process. So your view, sir?
Sir, this is Manoj
Normally,
Agarwal.
I think, sir, every IP gives information with respect to the land. If he has the information, the status of the land is cancelled or the land is with the corporate debtor. I think every IP gives this information in the IM. But maybe there are certain instances where the IP fails to give these information. There's some reporting by the IBBI also.
Like there is a situation where the land is the process for cancellation has started, but means the possession is still with the city. So it is just related to the informing the COC actual status. Even if the possession is with CD, should we hand over this to the authority during CIRP? Because there is a moratorium, so we cannot hand it over. Only possession is with us, though they have cancelled it. So
No, sir,
I think
they
the
are saying
provision
that
is
if the
only
land,
related to the informing it to the COC, the whatever is the status.
no, they are saying that the if the land has been cancelled before the commencement of the CIRP, then IP has to inform the COC and the adjudicating authority about this cancellation of the land, so that the informed decision can be taken by the COC. This is the issue, and they want that the IP should report the cancellation of land to the COC as well as to the adjudicating authorities.
So this
This
is
sounds
simple,
good.
I
There is
think.
no any problem.
This sounds good.
Sir, there is no any problem.
Yes,
Hello?
yes, sir.
You cannot.
Sir, there is no any problem. If before the CIRP, but it cancelled, it is like a set of processes is there, so there is no problem. And only you have to intimate. There is no any big thing.
Yeah, you can. This amendment is okay.
For the discussion sake, sir,
In
I'm
my
saying that
opinion, Ashish sir, in my opinion, the amendment is indicating only to the problem. There can be a solution also of this. See, why not through amendment, a mechanism should be developed where the land is cancelled by the authority and the company is coming under CIP after the cancellation. A mechanism should be developed to reallot the land to the CD on the terms and conditions decided by any authority, which may be NCLT or whatever it is, so that the interest of home buyer is not affected.
though I'm just adding to the what Shyam sir said, that if the land has been cancelled during the look back period, and if the SRA wants to give the complete amount, the complete dues of the land authorities, then authority should think that this land should be reallotted to the corporate debtor, so that the interest of the home buyer should be protected, can be protected.
Correct. Here, this amendment is directing to dissolution, early dissolution.
Yes, it can be done if because nowadays, now after this Supreme Court judgment in this Greater Noida Authority matter, when they are saying the Noida Authority is the secured creditor. No, Noida Authority is demanding the complete amount, complete their dues to be paid to the Noida Authority.
At
And
least the interest of the home buyers can be saved.
in these cases also where the land has been cancelled by the authorities, then if the SRA is willing to pay the complete amount, complete dues of the authorities, then it should be reallotted to the corporate debtor. Nowadays, in the Noida Authority, there is some Amitabh Kant report for the companies under CIRP, which provides for some privilege to be given to the companies which are under the CIRP. And they are saying that the promoters who is a defaulting promoter can make an arrangement with some partners, financial partners, who can bring in the money and they can pay the dues to the Noida authorities and they can rebuild the project. I think since the authorities themselves thinking about the company under the CRP, therefore there should be some provisions that if the SRA is willing to pay the complete amount to the authorities, then the authority should reallot the land to the corporate debtor.
Sir, if
Yes, sir.
if any authority giving land to any developer, so there is some terms and condition based on that they are giving. Okay, if they will not fulfill the condition, then certainly they will cancel. Okay,
No,
that
sir,
is
when the SRA is ready to comply with the terms.
No, sir,
then it can be done, no?
Let me finish, sir. Let me finish, sir. Let me finish. Okay, so then question go to the judiciary. Then you go to the kind of judiciary and the authority. Then, sir, you can take any action on that. RP can't take any action. Okay, that is the discretion of the judiciary. What they take the decision.
Anil sir, now we can take the benefit of the first amendment which we have just discussed. अगर authorities आती हैं आपके COC में और land अगर cancelled है, then there can be, you know, initiation of the talks. कि किस तरह से कर सकते हैं हम लोग.
Sir, that is the kind of window is open for every time. What you're saying, you can negotiate. You can go there and negotiate in their office. What is the problem?
You know, sir, how things happens with the authorities. You know, if the land has been cancelled, and even if the SRA is willing to pay the complete amount, the counsel for the authority will come and they will object the resolution plan. And if there will be regulation which says that if the SRA is willing to pay the complete dues of the authority after the reconciliation, then it should be reallotted. Then there will be no chance for the going to the authority for the negotiation. I think it is a good point from the Shyam sir.
Right. They are coming to COC also, and SRA will also be in the COC at the time of plan.
Because sir,
so can we give a suggestion to with this amendment about the mechanism to
yes. If everyone is agreeing that for the suggestion that if the SRA is willing to pay the complete amount, and if the land has been cancelled, we can say in the look back period, say in 2 years, then there should be provision which if the SRA is paying complete amount, then this land should be reallotted to the corporate debtor.
Sir, look back period for the only the ordinary transaction, perfect transaction. So
I'm saying that sir, there should be some timelines. Like if the land has been cancelled,
there should be some time frame, right? Time frame, correct.
Then it will be very difficult that the authority will reallot the land. Maybe they have created a third party interest on that land.
This thing will come only when the land is not reallotted.
Sir, that means that is the only for overall of the IBC system. Okay, because that moratorium is only allowed after the CRP date.
It will be only through IBC system, sir.
But in some cases, sure. So in some cases, there are a tripartite agreement between the developer, between the landowner, and also there are some service provider. All of them are related party. So in that case, there should be one exemption to the RP that if the related party would not give their claim and so the RP and would not provide the land detail whether it is expired or not, whether the lease date is expired or not. In that case, RP is not in position to say that yes, the lease date is expired or not. So in that case, if they are related party, RP should be exempt from background checking, like whether the lease date is expired or not. In that case, the related parties should bear the brunt, should bear the cost. These are the actual scenario that in case there are developmental rights are only with the promoter and they are constructing. In one of my cases there that the landowner is related party and they have not submitted their claim. So in that case, RP should be exempt from seeking if they have not filed their claim, and RP should be exempt from this background checking, and RP should go forward with the project.
No, I'm agreeing with the Ranjan sir. If the authority has not filed their claim, then RP will not be responsible for checking the background of the corporate debtor.
Yes,
with respect to land.
Be incorporated. Otherwise, in the after the resolution plan will be approved by the COC, if they will come and they will jeopardize the situation, then certainly there will be problem. So some exemption should be given to the RP in that case from background checking whether the list date is expired or not.
Only what happens is that if the city has some land, CRP has been started and the city has some land, and the RP came to know that the land has been cancelled. He has mentioned the fact in the IM that the land has been cancelled, but there is some land for the project, and he knows the details of all the home buyers, like they're the big inventory. And on the basis of the IM, RP has received some claims, and when the claim received and it has been approved by the COC, and when it is before the NCLT for the approval, then no authority come and it files objection on the resolution plan, saying that how RP can include a land which has been cancelled as asset of the CD. So what RP can do? RP has informed the stakeholders in the IM that land has already been cancelled. If someone wants to give the resolution for this CD, then RP cannot do anything.
There should be there should be some exemption from the RP in doing this background checking because the landowner is not filing their claim, and after passing of the resolution plan, after COC will approve the resolution plan. If they after that they will come, there won't be anything for them. That should be there.
I'm agreeing for this, sir. So any other views, sir, on this point? So we all are agreeing that the IP should inform about the cancellation of land to the COC and the adjudicating authority. And it will be added in regulation 40D of the CRP regulations. Then we are moving to next issue, sir. Next issue is item number 3 is empower COC to facilitate.
I have a question. Why is always the duty casted only on insolvency professional? They are bureaucrats, they are IAS officers, they move in our taxpayer chauffeur-driven cars, they have 20, 30 members in their personal office to assist them. Can't each government department go through the public announcement and do the necessary things? They sleep and we are made to be responsible for anything and everything. If they are not worthy of being in office, why are they paid and kept in office? They should be given, they should give resignation from their office or give up in slip.
Right.
Taxes and everything you make IP responsible are income tax, GST, land departments, those bureaucrats, and even in RERA, the same bureaucrats sit. They are senior and retired IAS officers of about 60 years of age. You write to them, they don't respond. You meet them, they say we know nothing. You just check our website. If they are just doing a postman's job, why should they sit over there and put IP into question? And why does IBBI always say IP should do? Why are these officers there for? If they're incompetent, let them be kicked out from their jobs. I'm sorry, but they should be given.
Devang sir, that is why you have been called a pillar of the IBC.
When we are the pillar, we have to support the building, but we don't have to support what is already written by white hats and white hat ravens.
Even you cannot hold the building on your own. You are one of the 4 pillars.
Anand sir want to say something. Anand sir, please.
I was just saying that this is beyond the ambit of our discussion. This is the only submission.
Yes, sorry, Anand sir. What is it?
This is beyond the ambit of our discussion.
Yes. But
improving
generally they are normally
or making the bureaucrats answerable is not.
No, sir. Anand sir, this was a feeling.
Now the IP has a soft target for
yes.
every institution.
Devang is right. Absolutely right.
No one can deny that. You are absolutely
that is the
right.
answer what I've got. Everything on the website. You check the website. They have not
Devang
even checked the land records.
Devang sir, let's cut it short. Okay, we all agree to your point actually. Ji sir.
Now can we come to item number 3? Empower COC to facilitate participation of association of allottees as the resolution applicants. The issue is the code aims to facilitate timely resolution of the corporate insolvency while maximizing asset value. In real estate insolvencies, allottees constitute a significant stakeholder group as a financial creditors. The current regulatory framework allows association of allottees to participate in the CRP as resolution applicants. While these requirements are designed to ensure serious participation, they may inadvertently exclude genuine stakeholder groups like the allottee association from the resolution process, and particularly in the real estate insolvencies, where allottees have been the most direct interest in the project completion. However, as highlighted by the report of the IIPI study group, there are some ambiguities regarding power of COC to relax eligibility criteria earnest money deposit requirements, and performance equity obligation in case of these associations. The proposal is to address these challenges. It is proposed to clarify by way of explanation that the COC is empowered with the discretion to elect certain conditions for qualified association of or group of allottees to participate as resolution applicant in the CRP. The proposal aims to amend the CRP regulations to expressly provide that the COC may approve relaxation to the eligibility criteria, earnest money deposit, and the performance equity requirements for allottee association or groups that represent at least 10% of allottees or 100 allottees, whichever is higher.
I agree to this point, sir. This is very welcome point.
Sir, there is
Even
no
the
any
main,
problem
So do I
because
also agree, sir.
yes, yes. Main
sir, there is no
hurdle
any
in
problem.
filing the plan by the association is the performance security, which comes into 5 crore, 10 crores, 15 crores.
Sir,
They have already
that is
invested their
also,
amount in the project. So this is
sir,
a welcome step.
sir, that
Yeah.
provision is already there in IBC कि employees और क्या नाम है employees can also present the resolution. There is no any problem on this.
This is good. This is really good.
Sir, actually, the question why this was raised, I tell you, in our this HDIL matter, this point had come up that association wanted to submit the resolution plan. So there was a question whether COC can, means how can there will be two different eligibility criteria, one for the market and one for the association. So from there this question has emerged, and this is the solution that has been suggested by the HDIL RP Mr. Abhay Manudane, that there should be relaxation. It should be there, though it is allowed under this IBC, but there should be a clarification on that, so that COC is not under double mind that this can be done.
Correct,
so I
correct.
think this is a welcome move. So this should be actually accepted.
Yeah, we all agree.
Disadvantage of allowing the relaxations are that if the home buyers are coming or the group of lotteries are coming or association are coming as the PRA, then no genuine builder will come, will give the EOI for this CD.
No, this is not disadvantage, Ashisha. Ashisha, this is a way to provide to give the advantage to the RWA actually. The purpose of this amendment is only this one. See, builder पैसा खर्च कर सकते हैं सर 4 करोड़ 5 करोड़ 10 करोड़ रुपए. अगर होम बायर ने 100 होम बायर है 1 करोड़ रुपए लगाए हुए 100 करोड़ तो वो पहले लगा चुके हैं और वो पीआरए बन के वो भागेंगे भी कहाँ पे सर? Why performance security is needed?
Correct, sir. That is not needed. But
See,
normally
why we take performance security as per the law कि कल को अगर प्लान पूरा नहीं कर पाया this can be forfeited और बीच में अगर वो withdraw करता है this can be forfeited, right? मेरे अगर होम बायर की पैसे लगे हुए हैं,
होम बायर्स ग्रुप आर नॉर्मली द डिवाइडेड ग्रुप्स. उसमें दो तीन ग्रुप्स होते हैं. तो इन द डिवाइडेड ग्रुप्स वन ग्रुप ऑफ होम बायर्स वांट्स टू बी द पीआरए और द एसआरए, और उसके लिए हमने लैक्स कर दिया हुआ है. दूसरा ग्रुप उसका अपोज कर रहा है, मे बी बिकॉज देयर सोर्स ऑफ फंडिंग इज ओनली फ्रॉम द कंट्रीब्यूशन फ्रॉम द होम बायर्स. तो अगर वो कंट्रीब्यूशन उनके पास में नहीं आया, they are not competent to
project wise
complete the
form G
project.
is allowed now. Project wise submission of plan project wise is allowed now.
I'm also agreeing for this point. Only I'm saying for the discussion point of view only that कि अगर वो contribution, because they don't contribute their own funds, they only depends on the from the contribution from the home buyers. और अगर वो contributions भी नहीं आया उनको किसी रीजन से, then they cannot complete the project. और उनके पास वो competency भी नहीं होती है कि वो प्रोजेक्ट कंप्लीट कर पाए. और इसमें चलते क्या होता है, नॉर्मली द रेपुटेड बिल्डर्स और द पर्सन हु वांट्स टू इन्वेस्ट इन दिस प्रोजेक्ट, they don't come because they know that their resolution plan will fail. तो ये एक डिसएडवांटेज हो सकता है जो आई एम प्लेसिंग बिफोर दिस फोरम.
Sir, actually that the association who are the association person, so what the builder do, they will also hire the subcontractor. Okay, they will do their job. Most of the construction company they hire the job क्या नाम है subcontractor. Okay, that's why who is the coming here, that is the RP is the duty. He will this feasibility if they can perform or not. If they will say they can do, so he will allow, no problem. You say that in airways So most of the pilot is going for resolution applicant. Sir, we will do this. Give us the opportunity. So there is no any big problem on this also.
Right. Anil sir, I tell you a case. I tell you a case wherein in CRP, CD is in CRP, and 3 associations are coming with a joint plan. They have submitted the plan with the NCLT, and it is the order is reserved in that case, and the plan is joint plan, but now they are going for a separate builders project wise. 3 associations are there. Plan submitted jointly, but they are hiring their own builders or contractor or whatever. So nowadays, these are being possibilities now.
Sir, if the person don't know about the construction industry, तो जो आपका contractors appoint करते हैं, they will submit a bill of say 10 crores rupees. जो आप अगर उसको ठीक से चेक करोगे, it will be only 1 crore rupees. अगर वो एक competent person नहीं है चेक करने वाला, then it will be very difficult to check the bills of the contractors.
आशीष सर ये चीज तो हमें चलनी पड़ेगी. अगर मैं नहीं जानता कि प्लम्बर कितने पैसे लेगा तो मैं उसको कितने पैसे दे दूंगा. But nowadays लोग vigilant है इस बारे में.
Yes, Anil sir.
Sir, you see the अपना Terminal 3 India International Port, Indira Gandhi International Port, Terminal 3. Okay, it is developed by the GMR, made by the L&T, or L&T subdivided this project in so many contractors. Okay, so you have to be hire a consultant, they will do their job. Who is the contractor at this? He has the only one consultant in this field. You can appoint and get the job done.
Yes, it is called the PMC, project management consultant.
It can be done easily. It can be done easily actually.
Yes,
we have the resources now.
Sir, I believe this particular proposal is just for EMD purposes. Whether the plan is to be accepted or not to be accepted, whether it is project-wise, is all in the domain of COC. Second thing is, when we are saying to exempt the home buyers or association of home buyers, is it only association of home buyers, or if they bid jointly with someone because they don't have the competence? I am only on EMD purposes. Whether the plan succeeds or not, whether the implementation plan succeeds or not, that is between COC and later on. I am only on EMD purposes. For EMD purposes, it is welcome. Second thing is the question which I think also should be addressed is whether if they bid not alone but with jointly, whether this exemption should be there in that circumstances or not.
Correct, sir. So it will be applicable on the allotee associations or the group that represent at least 10% of the allottees or 100 allottees, whichever is higher.
If the plan is submitted by the association of allottees
or group, maybe it is not association, but it should consist of 10% of allottees or 100 allottees, whichever is higher. Yes.
Sir, let me put my views. Sir, the issue here is not that whether they are competent or incompetent. It simply says that they should be allowed. Once they are allowed to give their resolution plan, the final authority always is the COC. They have to see the competency of the resolution applicants. Whether they agree with the association or not will be in the domain of the COC. It's just to make the things easier, because sometimes what happens is the resolution applicants which come, they ask say escalation, which is not acceptable to the home buyers. And now in number of cases I've seen, there are associations tower wise, not only project wise, even tower wise. So there can be number of plans in a single project also. So it simply says that they should be allowed to be represented as a resolution applicants. Final authority lies with the COC. They will look into the feasibility. So
that is there, Barsha, that is there actually. They are saying only about the cut in that EMD and performance security amount.
No. It is not only cut in the EMD amount, sir. It is cut in the qualitative points also, like the experience of the building, means how long they are working in. So all these qualitative points, they are eligibility points, they are being thrown out. You don't have any experience, how can you build it? So that also is the reason why this point has been taken. Not only the EMD amount. EMD is certainly a point, but the main point is qualitative references, where the builders are having more points. and this home buyers having 0 point, almost 0 point. So that is also a reason why it is taken, and certainly the decision is to be taken by the COC. Even if in cases I have seen that where home buyers are least interested to go for this type of constructions, they want some builder to come. In case if there is no builder is coming, then only these home buyers comes together and form some association to do their work or to salvage their money. This is what my experience is.
No, very true. Point taken. That is a practical situation. Sometimes the proposals are so exploitative that one doesn't feel like even allowing that proposal to go through. I think this point can be included.
Sir, if we are
So,
including this point, which is a very valid point, and even Manoj has put very valid suggestions, then we could add a suggestion not only for EMD, also for matrix criteria. There could be a special relaxation for
evaluation matrix
association
also.
or a group of landowners.
And
That additional point
qualitative
we could add.
points, quality. Yes. Yes, sir.
On qualitative points on matrix also we could add that they could be given relaxation compared to others. That
Right,
power
sir.
may be given.
Yes. So we have noted your observations on this issue number 3. So any other view, sir, on issue number 3? So now we are moving to issue number 4, which is clarification about inclusion of interest in home buyer's claim in CRP. Issue is the Insolvency Bankruptcy Code recognizes home buyers as financial creditors, granting them a significant role in the corporate insolvency resolution process. However, an issue exists in the treatment of notional interest for home buyer's claim. While Regulation 16A, subsection Regulation 7 of the CRP regulations provides for calculating voting share based on financial debt with an 8% per annum interest rate. This 8% rate of interest matches the opportunity cost of the money disbursed. The opportunity cost could be the interest rate on a fixed deposit or on a home loan, typically between 7% to and 11%. Thus, the average rate of 8% specified in Regulation 16A(7) is seen as fair for calculating the notice claim amount. However, in practice, there are inconsistencies. While many insolvency professionals use this 8% rate for claim calculations, some apply it only to determine voting shares and not for actual claim. IIIPI report noted that the situation frequently lead home buyers to seek orders from other forums such as RERA or consumer forums, where the orders would include amount of such interest. IIIPI study group reports note that this leads to increased litigation. Thus, there is a need for clarity in this regard. It is proposed to clarify that the provision of interest at rate of 8% per annum should be considered as part of the claim for the purpose of resolution plan and distribution under Section 53 of the Code. And this proposed amendment would create consistency by aligning the calculation of voting right with the value of the evaluation of the claims, resulting in a more coherent framework within the insolvency process. It could potentially reduce litigation by providing for interest within the insolvency framework, thereby reducing the need for home buyers to seek orders from other forums. So 16A(7), if we see, it provides that that the voting share of a creditor in a class shall be in a proportion to a financial debt, which includes an interest at the rate of 8% per annum, unless a different rate has been agreed to between the parties. My only point is that this 8%, they are mentioning the proposal only this about the 8%, but the 16A(7) provides at the 8% per annum or unless a different rate has been agreed to between the parties. Therefore, they should mention the complete wording of 16A(7), not only 8%. If the agreement with the home buyer said they will provide the 6% interest rate, then 6% will be applicable. If the agreement says 10%, then 10% will be applicable. So they are restricting only to the 8% per annum. I think it should be amended to say that it should be 8% or the as per the agreement. Your view, sir?
Or the decree amount which Harera might have given, or UP RERA might have given, because they assign 10.25%, I guess, in many of the cases,
No, sir,
instead of
they had
that
provided a
8%.
rate of interest and they had given a clarification how they arrive at 8% per annum. But uh, we cannot consider the RERA interest rate, RERA, the decree provided by the RERA. I
So
think we
if
should take only
decree
8% per annum.
so if decree has come, then
Yeah,
do
I
we
would
take
like
8
to say
only, or do we take 10.25?
No, 8 only, sir. 8. We will go by the IBBI ICRP regulations.
So even if there is a decree order by a court.
Yes, yes.
Here, I would like to say something, if permitted.
Yes, sir.
Actually, in the Interest Act, it was mentioned that the highest rate of the State Bank of India plus 2% is the maximum limit. It means today rate of interest with State Bank of India is 7. 7 plus 2 is 9. 9 should be the highest. Less than that, they can bargain the rate of interest.
So you are saying that the rate of interest should be 9%.
Not 9%, should be fixed deposit rate of the State Bank of India on that day plus 2%. It may be less also.
No. I
Sir,
think
it is fair enough. Otherwise, it will create a mess for
A
RPs.
plus 2%.
No. Issue is not of 8%, 9%, 10%. Issue is which is written in the proposal. Kindly just go through that again.
No, but there should be some maximum limit over there. So
maximum of what, sir?
In my view, it should not be more than 9%.
What I propose, if there are different rates proposed in the proposal in the BBA, then the 8% rate would be fixed. Because if there would be any printing mistake, then RP would get relief in going through the BBA and in going through the rate calculation as per the rate mentioned there. And if there would be any clerical mistake, if the promoter is offering 8% to someone, promoter is offering 10% to someone, in just one sentence would be added that if there would be differing rate by the in the agreements in the proposal, the 8% rate would be fixed, and that may be reviewed later on according to the
That is also provided in regulation 16A7. That's what I was also saying.
This is already explained in the regulations. Not more than 8% at all.
Yes, that should be. Otherwise, it
No,
will
sir.
create.
Sir, regulation says 8% or the agreement. It is not saying the 8% is maximum amount. If the agreement says for the 10%, it will be 10%.
Or if the agreement is not available, then the rate should be 8% of there. Or if there is any differing rates mentioned in the agreement, then the rate should be 8% only.
Correct.
So it will decrease the cost of decrease the work of the RPs actually.
Yes.
If the agreement is silent on the rate, doesn't it mean that no rate of interest will be paid to the home buyer or the parties between the contract was agreed? How can we assume if the interest rate clause is not there? It means that there was maybe it was deleted. There could have been intent that no interest is going to be paid also. So assuming when we say that if it is not agreed, it is 8%, it could be that if it is the clause is not there, it was 0% rate of interest. So it is better.
Agreeing with you, sir. Agreeing with you. If the interest clause is not there in the agreement, then we will take the 8%. But if there is interest clause in the agreement, then we have to take that rate only. Rajesh Shahji want to say something.
Sir, yes, sir. Actually, I agree with what right now person said. That yes, if there is whatever agreement is paramount. If there is nothing in agreement, then even 8% should not be considered. But yes, otherwise what you have told is fine, that 8% or whatever is in agreement should be fine. And that should be, because today, technically speaking, IPs are not following it. They are taking 8%. Why?
There's the language of 16A7 says that 8% per annum, unless a different rate has been agreed to between the parties. If there is no clause with respect to interest, then I think 8% will be applicable.
Means, to my mind, but yes, it should be very clear, whatever it is. But yes, agreement should be paramount according to me.
So may I say something?
Yes, sir.
Every financial creditor is eligible to take the rate of interest, but there should be a maximum limit to it. It should not go beyond that. Even if other rate of interest is mentioned in the contract, there should be upper limit. So upper limit or lower, whichever is applicable.
Yes, sir.
Hello.
Yes, sir.
Hello. Sir, actually, 8% limit is saying by the IBBI, but it should be added on that also. That is limit is decided by the IBBI on time to time basis. Sometimes the interest rate may be go down. So it's 8%. Sometimes it may be more or less. So it's in regulation should be mentioned. 8% should be now, but should be considered by the IBBI on basis on time to time basis. Not like that. It may be go in the coming year go down or like that. It should be added on that also.
Yes. Yes, sir.
Sir, my suggestion is, this is Manoj Agarwal. 8% seems to be right. This is only for calculation of claim, and this is for the calculation of voting rights. The PRA who is coming may calculate as and when whatever rate is there, as per that he may offer. So so there is no need of I think this is very simple point. Let it be 8% or as per the agreement. That is fine. There should not be any more complications in this. Only thing what they are trying to clarify is that some of the IPs are taking only for the purpose of calculating voting right and not in the claim. So it should also be taken in the claim. So that is the only point that they wanted to clarify, and that is a welcome move, that it should be taken in the claim also at 8%, and it should be taken in the voting right also at 8%. So it is simple, the agreement or 8%. Even if nothing is mentioned, then 8%. If something is mentioned, then that rate of interest. That's all.
Yes, sir. Thank you. I think, sir, every IP is taking this the claim amount of the home bias along with the 8% per annum as a claim amount also, as a voting power also. I think there is no ambiguity on this.
Sir, it is written in the this proposal only that there is an ambiguity, that some are taking only for voting and some are taking for claim and voting both. So clarify that ambiguity. We should take it in both.
Yes. So we are agreeing that this clause should be there, but
What is this?
Yes, sir. So I think everyone is agreeing that this 8% is okay, but it should be at par with Regulation 16A7, which is saying that the 8% per annum unless a different rate has been agreed to between the parties. So I think they want to make amendment in the 16A7, then they have to read it completely. And it will not be restrict themselves to 8% per annum, it will be as per the agreement also. So the proposal will be changed that, as per me, the proposal will be changed that it is proposed to clarify the provision of interest at the rate 8% per annum, unless a different rate has been agreed to between the parties, should also be considered as part of the claim for the purpose of resolution plan and distribution under Section 53 of the Code. Everyone is agreeing for this?
Yes, sir.
Yes. Okay. So, sir, any other views on this, or we can move to next issue, issue number
Sir,
5?
totally agree. The question is not an agreement. The question is just we have to keep this alternative issues which could come up in the eyes of IBBI. The question is not of agreement. We totally agree. But these things could come up in the distribution 53 waterfall when the money is available. That when the agreement, etc., is not there, etc. So just keep IBBI aware of these issues if they want to take any other policy decision.
Yes, sir. Noted, sir. Yes. Okay. So, we are moving to issue number 5, which is representations of large number of creditors through facilitators. Issue is the current provisions of the IBC and the CRP regulations allow only one authorized representative for per class of creditors regardless of the class size. In cases where a class has a very large number of creditors, a single AR may face challenges in effectively representing and communicating with all creditors. This can be potentially lead to inadequate representation of diverse interests within the class and communications bottlenecks. Proposal is to address this issue. We propose allowing the appointment of facilitators for large classes of creditors, primarily to improve communication and representations. So, your views around this? Normally, in
So this
the
amendment says you are providing a helping hand to the AR.
yes, sir. But who will be the helping hand? Who will be the facilitator? What will be the eligibility criteria of this facilitator
Yes,
is
it's
not
not
provided with
there.
the amendment regulation. I think they will also be IPs, but whether they will report to the AR or how they will function, it is not clarified in this proposal.
Yes, the clarity is needed. Who will be the facilitators?
And
What
to whom they'll
my
report.
understanding is that there are several associations. So these associations are having their own committee. So these committee members may be the facilitators, and they can, in place of talking to all the home buyers, the AR may have a discussion with these committees, and then these committees may pass on the messages to the home buyers or discuss the points. That may be the idea behind it, but there should be a clarity that who should be this facilitator.
Yes, I'm agreeing with her. I think the every home bar association has some
नहीं नहीं
representative. They can be facilitator, but there more clarity is required.
facilitator should be IP. नहीं, the we should give the advice that the facilitator should be IP. That is the scope for the IP also. They can do some work on this building.
Yes, I agree with this proposal. Okay, the facilitator should be IP.
As per my view, the facilitator should be the association of home buyers to be made as a committee, like just a committee of buyers associations consisting of 5 buyers.
No, sir,
They should be
Prabhakar sir,
aware
you are
of and
going
they
to
can.
Prabhakar sir, you are going to give them a legal status actually to facilitator, right? And if
Yes,
you are
yes,
taking a
yes.
person from the association, it will create problems for the AR as well as for the RP also.
Maybe.
Yes, that's right.
So
Rajesh,
the
as you want to say something. Rajesh,
person should be IP only.
Yes.
Sir, there are
The matter it is how to communicate the things to the home buyers. And in that case, AR needs some persons, needs some facilitator to communicate what the thing have done with the COC. And that should be communicated to the home buyers as a whole. So in that case, a single person, I don't think, would be capable to communicate all the things to the home buyers at large. In that case, I was in opinion of forming such kind of committee consisting of home buyers, selected home buyers who can communicate the things to the home buyers.
Here I would like to
Sir,
suggest
capability can be increased,
if facilitator is IP, then he can contact the home buyer association or somebody else. But ultimately, legally, he is responsible to the RP or IRP.
Sir, my view is that we can take the authorized representative of the home buyers or the association as the facilitator. But the difficulty is that they don't have the knowledge of the IBC or the CRP regulations. So we
Correct.
are also have to go through along as in terms of the regulations of the IBC. Therefore, we cannot make this representative of the home buyers as the facilitator as
In
per
that
the
case, sir, in that
company's
case,
policy.
Absolutely right, sir.
apart from problems with the home buyers, the person should be capable to give them the solutions also.
Rajesh
When
Shaji
you are
want to
going
say
to
something.
open,
Rajesh
Rajesh
sir,
Shaji, please.
sir,
see,
Yes,
actually right now
sir,
I am facing this
yes,
problem. The
Rajesh
problem
Shaji,
is,
please.
shall I?
Yes, yes.
Yeah, see, basically what we are talking is that we require more support for AR. Right now,
Yes.
AR himself, if you are talking, AR is not paid. What support is going to get? Who is going to pay the cost? That is first thing. Second thing, when you are telling we are increasing more complications, 4 people telling 4 different things may not be same, and it will create more confusion to my mind. I don't think this is
No,
a welcome move.
Rajesh sir, this is not with every CRP. You know, where the projects are 5, 6, 7 projects are there, then this can be taken
No, but
care
still,
of.
see, the problem is that's what I'm telling. Even if that is the case, see, if one CRP, one person is fine, because the point is, if you're so for example, whatever I'm telling, there is one particular regulation we all are telling, and if we all interpret it, it won't be tell someone, it won't be same. So it's going to create more. उस बंदे ने ये बोला, इस बंदे ने ये बोला, and it will be a bigger problem, and there won't be any solution to my mind, because anyway it is confused thing. But that's all. Means I'm
Sir,
not
what I understand is this facilitator is not the there is no need of any IP to be the facilitator. They should be from the home buyers, because home buyers believe only home buyers means people from among themselves. They believe them, and it is for communication purpose only. To communicate it properly, it is always better to you talk to 100 people, or you talk to 2-3 people who can then make them who can work as a bridge between you and these home buyers. So I am working like this in this HDL matter. I am the AR of home buyers, and there are 7, 8, 10 projects, and each project is having their committees. So committee members are getting in touch with me to take the informations and to discuss, and then they are communicating them to on their WhatsApp group. And this is just like direct home buyers are also calling me, but the home buyers are in number 7,000. How can I handle these much people?
I appreciate
So
that.
it is always better
I also endorse the views and opinion and experience of Darshan sir have already gained during his proceedings. So in that case, to communicate the things and convince the home buyers, it is really more typical by AR as well as insolvency professionals also.
Though the clarity is needed, who should be the facilitator, but I don't think we should suggest that IP should be the facilitator. That will add to the complications.
The only issue will be that there can be a conflicting interest between the AR and this facilitator.
True.
AR is not having any interest. He is only representing them. So my understanding is that they should represent whatever is the interest of the home buyers.
But who will decide that? See, the point is, who will decide what is the interest? See,
the interest is to get the resolution plan. That's all.
No, that's what that is.
So any resolution plan getting approved, the home buyer's home is being means they are getting the home. If they are getting the home or the money, that should be the ultimate interest. And I have tried to drive all the committees to that point only, that you should focus on getting the resolution plan approved. That's all.
What will the role of these facilitators in the meeting with the class of the home buyers? It is not provided in this proposed amendment.
Yes, there should be a clarity on the role of facilitator and their legal status also. But I think there should not be IPs. There is no need of IPs. They should be from the home buyers group, either the committee of their association or the group. They can select some 1-2 people from each project, and then AR get in touch with them, and then the communication is being properly done. That's all. That is the need of a facilitator.
Ashish sir, the purpose of the amendment, for bringing the amendment is to share the burden of the AR only. Nothing else.
Yes.
So
Only
अभी
thing,
रोल क्या है
only
इसका, क्या रोल रहेगा? रोल will be same as is of AR to communicate with the home buyers.
then the role will be to assist the AR.
Yes. To role will be to assist the AR when there are 5, 6, 7 projects.
Sir, question is that if there is a huge work is there, so what is the problem to make the facilitator to the IT? Let the ask the IBBI to give the definition of the facilitator also. What is the role and
Correct.
what is the
Let them give the qualification.
Yes. What is the problem? If their work
Right.
is huge, so what is the problem of hiring the 2, 3, 4 IP as a facilitator?
Ashish ji, you can suggest the qualification of the facilitator.
Qualification of facilitator, correct, sir. Because some views of some of the members is that the representative of the home buyers can be facilitator. In that case, I think he will not be needing any salary or the perks for acting as the facilitator. He's only advising or the assisting the AR.
सर वहाँ पे अपॉइंटमेंट के लिए बड़ा मामला गंभीर हो जाएगा कि किसको अपॉइंट करेंगे होम बायर फैसिलिटेटर. वहाँ पे आपस में लड़ाइयाँ होती हैं बीच में.
Sir, there should be only the part of a kind of election, means just like to elect somebody as a facilitator from or by the buyers or buyers association. In that case, I would suggest
they can suggest a name. Yes.
Yeah, in that case, their remuneration should be fixed by the buyers and buyers association, as well as the eligibility criteria should be framed by IBBI. Instead of just putting the qualification, there should be the eligibility criteria.
Correct. ठीक है आशीष जी, let's proceed further.
And then if the class consists of say 1,000 persons, then AR should speak with only those facilitators. They are representing their own associations, or he will speak with all the home buyers in the class of meeting. Like say if there are 5 projects,
AR के होने के बाद भी RP भी कम्युनिकेट करता है ना सर होम बायर के साथ में.
नहीं करता है सर. मैं कह रहा हूँ कि
same way if there is a need, then AR can also communicate directly with the home buyers also, and he should be.
Sir, the same view has Darshan sir already elaborated regarding the communication and convincing the buyers. What happens कि AR या RP से buyers convince नहीं होते easily, rather than कि home buyers और उनके एसोसिएशन के कोई पर्सन अगर उनको एलोबरेट करते हैं और कन्विंस करते हैं तो मैटर यहाँ पे आता है क्या कि केवल हम इंसॉल्वेंसी प्रोफेशनल या IBBI की रूल्स और रेगुलेशन कम्युनिकेट नहीं कर रहे हैं. The matter what it is right now is status of CRP proceedings, क्या चल रहा है, कैसे चल रहा है, क्या होना है, नहीं होना है, that has to be communicated to the buyers to get their opinion or to form their opinion.
Then responsibility of the facilitator should also be defined.
Definitely.
May I say something, sir?
Yes, sir.
The facilitator is a legal position once it is part and parcel of the rules or regulation or whatever it is. Then we have to think twice before getting any outsider as a facilitator. That is my summation. Otherwise,
Very well. The point is well taken, sir. Very good point.
तो हाउ टू कंक्लूड सर? श्याम सर आप बता दो एक बार कंक्लूड कैसे करना है इसको.
नहीं ठीक है सर, एक क्वालिफिकेशन ले लो उसकी जो है एलिजिबिलिटी जो रहेगी फैसिलिटेटर की एंड हिज रोल एंड रिस्पांसिबिलिटीज.
ठीक है. Otherwise, we are agreeing that for the appointment of facilitators.
And I would invite you in the previous point also regarding the rate of interest. Suppose in a project, number of buyers have been offered rate of interest at the rate of 18% and number of buyers have been offered at the rate of 14%. And some of the buyers have been offered at the rate of 8%. Asset is the same. In that case, how you will deal with either as per agreement or what would be the condition to accept the rate of interest? ऐसे भी होते हैं कई सारे केस में.
Here,
In
I
that
would
case,
like
sir,
to suggest, if permitted,
yes,
there
sir.
should be a maximum limit fixed by the board. That's all. Whatever may be the contract, it should be less than that, but it should not be more than that. There
As
should
per
be
my
some.
opinion, there should be only the rate of interest, that is 8% has been fixed, whether for voting or for claim. It should be fixed for all. Instead of, because for the same class of creditors, the rate
Yes,
should be fixed at the same rate.
yes, yes.
Yes.
So then what you will do for financial creditors? From one financial creditor, you are taking at 18%. From other financial creditor, you are taking at 8%. Will you
I am
calculate for
saying,
all the
sir,
financial creditor
Yes,
at 8%?
yes, it
sir, I am
should be
saying for the
any
creditor in a
any rate
class.
of interest, any rate of interest fixed by the IBBI should be
Rate
the
of interest.
benchmark as the highest, whether it is 8% or 9%. That is up to IBBI. But there should be some ceiling on that. It cannot be go here and there.
That will create more bunch of litigations, sir.
I don't think so because in the Interest
Sir,
Act 2002, it is very clearly mentioned highest rate of fixed deposit given by the SBI plus 2% will be the maximum limit. That comes to today at 9.1%.
So that
sir,
applies to cases where rate of interest is not given or expressed.
sir,
Sir,
income
under
tax is
Sir,
giving only
that
6%.
IBBI power to override Contract Act.
sir, 1 second.
Sorry.
Sir, see, the point is, right now, home buyers, I'm representing one place, and they are telling that get me money at 8%, and yes, I'm fine with it. So, at what percentage they get? So, it doesn't make sense in we deciding what, or IBBI deciding what percentage it should be, whatever contract rate, or if it is not there, then 8%, if at all.
Yes, I agree to that.
Sir, income tax is giving only 6% on the, nobody is telling about that. Okay, thousands crore rupees is on, they are refunding the TDS. So nobody talking about that 7%, 8, 9%. Everybody is kind of certified in 6%. There is no any problem.
Sir, I think we have noted your observations on issue number 4, the interstate part, and we have noted now this discussion part also. Now there are two issues left. I think we should proceed with the two items. And with respect to representation of large number of creditors to facilitators, yeah, we had agreed. Or we need the more clarification. We had noted that. The issue number 6 is to propose the proposal to disseminate committee of creditors minutes to the meeting of all creditors in a class of a real estate project. The issue is the minutes of the meeting in a real estate project undergoing insolvency contains discussions and decisions about the project status updates, financial decisions affecting project timelines for project completion, issue or challenges faced in resolution process. Any application filed before the tribunal, court or by stakeholders, voting outcome on critical decisions, CRP costs, etc. So Regulation 25, Subregulation 5A of the CRP regulations requires the RP to circulate the minutes of meeting to all the participants by electronic means within 48 hours of the said meeting. The AR is required to share the minutes of the COC meeting to the financial creditors. It represents as per section 25A2 of the code. Regulation 16A10 of the CRP regulations provides for the AR to review the minutes of the meeting prepared by the RP and facilitates the authorities to have access to any information or documents required to form an opinion on issues discussed in the committee meeting. In the normal CRP cases, these creditors are represented by in the COC. Since the creditors are represented in COC, have access to discussions and minutes of the meeting. In case of real estate cases, the home buyers who are financial creditors are represented by the AR. The AR should brief the home buyers about the discussion in the COC, or there are cases where there is a lack of communication between AR and the home buyers. Proposal. It is felt that the access to minutes of meeting of the COC in real estate insolvency cases to the authorities of real estate project will ensure them to stay informed about project developments, act as single authoritative source of information, provide valuable inputs and feedback. This will then enhance transparency and counter rumors and misinformation. Proposal is to facilitate the RP to place the minutes of the COC meeting on the website where all the CRP related information is published, uploaded by the RP. The minutes shall be provided through secured login system to the authorities.
Agreed,
So
sir.
they are saying that we should upload the minutes in the case of the real estate cases at in the website or any web page where we are keeping all the information about the CD, and we have to make a separate login for the home buyers so that they can log in and they can see the minutes. So your view, sir?
That it is very much interesting and also acceptable. But the query is, who will bear the cost? Because in number of
Exactly.
cases, CRP cost not being ratified. In number of cases, if suppose CRP it is of real estate company, it is a bigger company, then company can have the fund to bear such cost. But in a smaller cases, when CRP cost is not ratified, how RP can fund it and how RP can manage it? Who will bear the cost?
Correct,
Sir,
sir. Agreed.
we are being given all the amendments and that, but no discussion on our fee and our expenses.
Even in number of cases,
Right.
CRP
But
cost not being ratified by the COC.
sadly, after this amendment, we have to do this.
So, sir, from where we will take the finance for the making all the logins for the home buyers?
I'll keep no
Sir,
no comments, sir. No
unnecessarily
comments
cost
about
this.
it.
This unnecessary, Jonathan.
Sir, I think, sir,
sir is
I think
right.
that
This will increase the cost actually.
I think the AR is complying with his duty by circulating the minutes of the COC meeting to all the home buyers, and all the home buyers are getting the minutes of the meeting of the COC.
Yes.
And
And
if
RP has the authenticated mail of the home buyers.
yes, and if any home buyers has not received the minutes, he can ask the RP or the AR to again to share the minutes.
Absolutely.
Yes, this is the extra burden on the RPs, I think.
This is an unnecessary exercise.
Unnecessary, right.
Putting responsibility on RP to circulate minute through email, it is okay, but keeping a logging or putting it on website.
I'm muting.
Who's this boy?
Sir, muted all. Please speak after unmuted yourself. Yes,
I
sir.
was saying that circulating minutes by RP to AR or all the plot buyers would be convenient and would be possible. But creating a proper website, putting login credential and causing extra cost or burden, that would be the additional cost on the CRP as well as, and the issue is who will pay the cost, because in number of cases CRP cost not being ratified. So how IP can fund that amount or fund that cost? That is the main issue.
Moreover, Prabhakar sir, it will increase the workload. मेरा login ID correct नहीं है, ये नहीं है, वो नहीं है. अब कितने लोगों को treat करोगे इसमें? एक आदमी अलग से रखना पड़ेगा उसके लिए.
4,000 IPs with hardly 50% of us having cases. There are 60 members in IBBI team, and they cannot have IBBI portal which is working properly. And with a budget of over 50 crore rupees of IBBI, much more than 50 crore rupees, IPs don't have fund. They don't have such a big team, and number of buyers could be much more than that also. With this limited infrastructure and finance, how will we be able to do all these things? This is a genuine difficulty. Even IBBI will understand how difficult it is because they've experienced it. So maybe at philosophical level, it is very great. But at practical level, it is impossible to do until and unless we are helped with other infrastructure and finance facilities.
Sir, in case of big assignment, it may be taken. There should be a limit in this, that this should be made applicable only in case of big assignments where the number of home buyers are more than say 500 or something. That may be suggested.
Yes.
So such IP portals, etc., charge 3.5 to 5 lakh rupees per month to have all these services and facilities, etc. who will pay us 5 lakh rupees per month or 3 lakh rupees per month to do such things?
Right,
Just
Devang
an
sir,
IT
very right.
submission portal.
Right. So we oppose that, yeah, I think.
Rajesh Aji. Yeah.
Aji, sir, see, I am fine with you do everything. The point is who is going to give money, and then someone should talk of it. No point in just making statements, because the point is right now, if we see, even if the CRP cost is approved or COC approves it, payment is not done. Frankly, there should be one resolution that if CRP, whosoever has started CRP, and if it's not happening, that the person who has initiated, who is, they should be penalized for that rather than penalizing IP or someone else.
Sir, even for e-voting, after doing e-voting, they disapprove e-voting charges. This is the reality which we are facing.
So what I'm trying to tell is, yes, if even if they approve or not, the COC members, they approve it and they don't provide the funds, what's use of it? So our IP or IRP just keeps on fighting on all fronts and begging. It doesn't make sense. First, provision should be there from where funds are going to come, and then only any amendment should happen.
So this amendment is a conditional.
Real
It should
estate,
be a
as far as
conditional
real estate is
appointment.
concerned, it's very
Amendment.
serious
Sir,
thing.
there is no grievance redressal for any complaint against IBBI officials. There is no code of
No,
conduct.
that is, I'm not talking of that. I'm telling simple. We will do everything. First give money and then talk.
This has to be.
Ma'am.
We need assistance in
Yes,
help.
sir.
We
I
don't
have some
any-
submissions herein. Sir, I have a sub-submissions herein. I have done all these things because I am an AR in one of the matter wherein I facilitate the home buyers to, provided the login access and all these things. But the home buyers repeatedly, didn't approve the CIRP cost that we have additionally incurred for the benefit of the home buyers so that they will get all the information on the platform by logging itself into the same. So the question again that if the COC is not going to approve the CIRP cost which is being incurred on behalf of the home buyer, then ultimately who will bear the same? First thing. Second thing, even if the RP has some funds in its bank account pertaining to certain EMD in person to the resolution plan, and did he has the authority to utilize that EMD amounts interest to meet these small expenses, which is bare necessity in such a huge home buyer matters, wherein more than 1,000 home buyers are there.
Ma'am. These are only for the specific purpose actually. How this can be used?
No, that is the same. That is the thing is there, but ultimately, who will bear that cost for
that is
as
a moot
AR,
point.
as
Yes.
an AR, we are facilitating all these things, but we are paid only for attending the meeting.
Correct.
And we are, doing the work more than the RP. So my humble request to the organizers as well to add the efforts of the ARs in following these CIRP process because they are acting much more than the RP side. They are doing equivalent work with the RP.
Maji, I'm not agreeing with your view with that the ER do more work than the RP.
This is a debatable point actually.
Sir, kindly appreciate the efforts because
Okay,
AR
95% of the attendance will oppose that.
because 90% are RPs, not AR. Is it so?
No. ARs are also there, and there are RPs also.
I knew Shyam Arora is there. He's
I think
RP also and AR also.
I am here.
Sir, kindly appreciate the efforts of AR as well, na? Because AR is being every time asked.
In every forum, everybody thinks that RP has a lesser work to do. Everywhere it is the situation.
Even AR is saying RP has less work to do. Even AR is saying that. Although in some other matters she may be RP.
Yes, because the RP
but a
shift
good point
half
is
of the
raised
burden to
by
the
Maya.
AR to deal with the home buyers, and the home buyers sending multiple emails, but RP is not responding the same.
I think, sir, if they are proposing this amendment, I think that we should suggest that all these statutory compliances to be done by the RP should be borne by the COC members.
By the COC member. Yes, not only approved but
and
also paid.
RP should be authorized to raise these funds from the COC members or the home buyers, and only if RP gets these funds as a contribution
No,
from the
Ashish sir, it
COC,
is already
then only
there,
he
but
can comply with this.
it is
Otherwise,
already
the
there,
NCLTs are
but no binding effect.
Yes.
So,
COC
But,
approves but doesn't
RP,
pay.
but RP can say that since he has not received the funds from the COC, therefore he is not complying with this provision.
No, Ashish sir, as far as amendment is concerned, we are simply
Yes.
saying we are not in favor of this amendment for the reason being it will put additional burden on the RP.
Yes.
and funding is not available.
No,
These
cost is more
And
important.
for
Cost
no
has to be
reason.
paid.
And for
Cost
no
has to be
reason.
paid.
IBBI is least concerned about the burden of IPs. They only want to put more and more pressure on IPs. They are inhumane in my humble understanding in the way in which they are putting problems. After knowing what issues IPs are facing, yes, there are some wrong IPs, but everyone is not wrong. Second thing is, except for IPs or regulated entities, including IPA and IUs, no one is bothered about IBBI, neither banks who sit in COC nor government departments. No one cares about IBBI or anyone. It is only us who are regulated by IBBI wonder. If they say anything, nothing is going to happen on them. So even if they say you have to do funding, you have to do so and so things, they are not going to listen. This is a practical issue which IBB has to take up with them at their level. Only then things are going to improve.
Because the sword of the IBBI can hang on IP only, not on the other person. So IBBI sword is always hanging on IPs.
Ajay sir is back after lunch.
Now it's my dinner time. After sunset, I do not take anything, even water also.
Okay, sir.
चलिए
So,
आशीष
sir,
सर आगे चलते हैं. हाँ.
we are opposing this proposal in issue number 6. Issue number 6. Yes.
Yes,
That,
we are not in favor of this amendment.
हाँ, ठीक है. Okay. So, sir, last issue is streamlining position handover in real estate projects. I think this is the most important.
Yes,
because so I'm reading the issue. The triple IPI report on real estate has emphasized the need to implement the position handover proposal from the discussion paper dated November 6, 2023 for providing necessary clarity. In this context, the CRP insolvency resolution professional face the critical task of ensuring business continuity, including the management of inventory. The real estate sector presents a unique challenge where, in many cases, creditors have fulfilled their contractual obligations and corporate debtor has completed unit construction. Yet the formal handover remains pending. Currently, courts have exercised their inherent powers to permit ownership transfer and registration during CRP in select projects. Honorable Anclet in company appeal this in Alok Sharma case observed that CD is the owner of commercial space and has accepted that the possession was with the appellant. Admittedly, the appellants are allottees of commercial space in Carol Breo. Although the CD had handed over the possession of commercial space to the appellants, admittedly no sale deed was executed by the CD in favor of the allottees prior to commencement of CRP. The houses so constructed is the business of the real estate company, and the value of the sale of those houses will always appear in the credit side of the profit and loss account as a revenue from operations. Hence, this is not an asset in case of a real estate company, as it is recurrent business activity of the for the company, and it is a business for the continuation of its operation as a going concern, even during CRP. We are unable to sustain the views of the respondent RP that these houses registration will violate moratorium under Section 14 of the Code. Registration of all these houses is a procedural requirement in case of real estate company where the appellant are already in possession of these spaces. Right of home buyers cannot be affected adversely in the CRP and their interest is to appropriately preserved and protected within the parameters of the IBC code. Further, the Honorable Supreme Court in the CRP of Hacienda Projects Private Limited in New Oakland Industrial Development Authority versus Lotus 300 apartment. The petitioner Noida must adopt a positive and proactive approach to ensure that the flat owners buyers are given possession of their flats and that the registered deeds are executed. CEO of the Noida shall appoint a nodal officer to ensure that there is a compliance with this order. The nodal officer will interact with the Lotus Senior Apartment Owners Association as well as the resolution professional of the builder company, which is now under the CRP. The RP shall sign the documents on behalf of the builder company developer. The list of the flat buyers, owners, flat numbers along with the area will also be given by the resolution professional. In the real estate case, the immovable property of the inventory is the inventory of the real estate business, which needs to be sold in order to run it as a going concern, and the accrual of such revenue is provided in the profit and loss account. So, dealing with the same for running the city as a going concern is not a violation of the moratorium, for the reason that insolvency professional, while doing so, may impinge on the rights of other creditors as a requirement of approval of the COC has been kept for balancing the rights. That there is a strong case for allowing transfer of immovable property in appropriate cases if the concerned stakeholders, that is creditors, have approved the same. Thus, where the lotteries have paid the full amount and occupied the unit or position of a plot, uh, units, apartments, or building, the transaction need to be formalized through transfer of such unit during the resolution process with the approval of the COC. Further, units which are not under technical position of lotteries should not be included in the IBC process by the RP. The objective in the resolution of the real estate project is a smooth handover of units to the rightful home buyers. That thus to expedite the resolution process and to avoid delays due to unnecessary holdups, the lotteries cannot be given the option to take possession of the units on as is varies basis or on payment of the balance amount, if any, after taking into the accounts the funds due and the funds required for completing the units after approval of the COC. Once units are handed over, registration sublease should be done. Proposal to facilitate the smooth handover of the occupied units or where the position has been transferred to the home buyer, it is proposed to allow RP to hand over the ownership of a plot, apartment, or building to the allottees through transfer during the resolution process with the approval of the COC. Further, to avoid delays due to unnecessary holdups, it is also proposed that with the approval of the COC, RP may also be permitted to hand over the possession of the units to the allottees on as is varies basis or on payment of balance amount, if any, after taking into account the funds due and funds required for completing the units.
Ashish ji,
Yes.
in this draft, the very vital points has been missed. The vital points is that the in case of the company having more than one or two projects, the CRP should be commenced project wise, not company as a whole. If there are, if suppose there are all projects are in limbo or there are incomplete projects, then it can be commenced for entire projects, entire CD. But if there are suppose 10 projects, 5 projects have been completed and 5 are incomplete, then CRP should commence for 5 projects or project wise as per the allottees. And this point was raised before the NCLT principal bench in Raheja developer matters. And the order was passed 3 days back. In the Raheja developer matters, NCLT principal bench was in dilemma what to do because there are 100 projects. Only one project's home buyers approached the NCLT, and this order has been recorded in this. I'll just share the order sheet that what NCLT has said in the just a moment. Principal bench, just a moment. ये क्या हो गया? हैंग कैसे हो रहा है?
No, Ajay sir, we know about that. We know about that. It's fine.
नहीं, एक मिनट, just a moment. हाँ, ये I will just share one order sheet, which was turned down by the NCLT yesterday itself. See what is the observation made by the principal bench in its order. Just yes. The provision is allowing the RP to invite resolution plan for each real estate project or group project of the CD as the case may be. In this background, we do not think that it fit to go beyond the powers of this adjudicating authority. It is for the legislature to draft and come up with the amendment in the existing law to cater the all kind of situation. But what the situation was before this, it is pertinent to mention that the rule and regulation of IBC do not allow the AA to admit the CD into insolvency partially. At most, clarification to regulation 36 of CRP regulation is provided under this code as it is. So only in this matter, only one project home buyers approached this NCLT for CRP. However, this bench was compelled to admit the CRP for entire CD. And then what happened before enclate yesterday? I'll share the enclate order dated 21st November 2024. It is just 4 pages, or we have had the appeal has been filed against so against 19th 11 2024. The submission which has been raised by the counsel for the appellant is that the applicant who has filed section 7 application with respect with section 7 application relates to only project Raheja Sheila's low rise situated at sector so and they had themselves prayed to AA to commence the insolvency with regards to the project to which applicants were concerned. The learned counsel for the applicant submits the AA itself has appointed an advocate commissioner who so I'll just come to the relevant points. Learned counsel for the applicant submits that the issue pertaining to the electricity. So now come to learned counsel submission. 8 weeks also just one thing. Considering the facts of the present case, we are of the view that for the time being, as was prayed by the applicant or respondent herein, the insolvency may convene to one project, namely Raheja Sheila within bracket low rise. IRP may collate the claims with regards to the project and submit the status report. IRP shall take all endeavor with regard to assistant and management of the employees of the corporator to obtain the OC and to do other completion which are required for handing over the project to the allottees. Issues notice, let reply file with it. Status report filed within so. IRPs to take all necessary for corporator. Appellant may obtain the given.
Ajay sir, we are agreeing with your point that this.
So these
you are
issues
talking
were
about
resolved by these issues.
But
yeah.
yes, yeah, yeah, I think you are talking about the reverse CRP. That is a separate issue.
No,
Here the
project
issue-
wise CRP. Project wise CRP.
No, there is a regulation for the project wise CRP.
Which regulation?
No, there is an explanation in I think regulation 36, which says that the RP can do the project wise CRP.
No. RP can do the project wise resolution, but AA is not authorized to pass the admit the
Correct,
section
correct.
7 or section 9 application project wise. AA is authorized to admit the application as it is for CRP of the entire CD.
No, Ajay sir, based on the judicial pronouncement from 2022, it is happening. AA is giving insolvency on a single project.
But you just see the order 19th. It is just 2 days back.
That is fine. I can give you a number of examples where the project-wise insolvency has been given by the AA.
But here the issue is that in case of where the possession has been given to the home buyers, here they are proposing that the IRP or the RP should be authorized to do the registry or transfer the ownership to the home buyer.
Correct.
See,
This is the proposal.
I have just taken this point out of the box, and this point should also be added in the regulation that the AA should also allow to admit the project by CRP.
That is not the present amendment, sir. That is already there now.
We can stick to the agenda points, right?
Yes.
In number of
ऐसे तो बहुत कुछ
cases,
change कर सकते हैं, sir.
Yes.
in number of cases, AA has allowed giving direction to IP that the power of the board of directors vested in IP, so IP can do that. But for that, case wise, we have to obtain or we have to seek for the direction from NCLT. If this kind of directions be classified by way of notification or circular by IBBI,
NCLT itself admitted and NCLT itself admitted that I am helpless. NCLT principal bench said I am helpless because law does not permit him to admit the CRP as project wise.
Okay, Ajay sir, please let's discuss the present amendments here.
Yes, sir.
My point to Ashish ji, please note down my point that project wise CRP should also be allowed.
We have noted your point, Ajay sir. We noted your point, but
Thank you, Ashish
I
ji.
just want to say that our time was till 4:30. If Anjali ma'am is here, we are extending the time till 15 more minutes to complete this issue.
Please go ahead.
Here
Yes.
the issue was whether to hand over the possession of the plot or flats to the home buyers during the CRP process. The main issue it was. So in that case, because there is no clarity in the code as well as the guidelines, IP needs to get the approval of AA, seeking direction to hand over the possession to the allottees or plot buyers by way of registering the conveyance deed or sale deed. In that case, if the particular guidelines or particular that's a guideline we can say or particular code would be amended, allowing IP or RP to go for registration of conveyance deed or sale deed in form of in favor of plot buyers or flat buyers during the CRP
Prabhakar, this
process. That would be
amendment is
much
for
better.
that only. They are authorizing RP to do the registry for in favor of the home buyer.
See,
But
Ashish
I
ji, here
think
one point one should be
I just
added.
have 2 minutes. There are
Yeah,
two issues
please.
with respect to this. That normally the CD which are into the in the CRP or the projects which are into the CRP, we have not received the OC occupation certificate or the completion certificate. In those scenarios, if we even if the suspend director has given the position to the home buyers, it will be practical for the this RP to give the position to the home buyer because it will be a risk factor. We don't have the structural audit whether the structure is safe to give the position to the home buyers. This is the one point. Other point is that if some resolution plan has come to the RP, then he must be asking some escalation charges or extra amount for the completion of the project. If we give the possession only on the balance amount, then how the complete project will be completed?
नहीं सर,
So
आप
this is
बाद में वो लिखा हुआ
this
लास्ट लाइन में, प्रपोजल में लिखा हुआ लास्ट लाइन में आशीष सर,
नहीं वो कहते हैं कि सर ओनली द
आफ्टर
बैलेंस अमाउंट
टेकिंग
लेने
इनटू
की बात
अकाउंट द
करते हैं.
फंड्स ड्यू एंड फंड्स रिक्वायर्ड फॉर कंप्लीशन ऑफ द यूनिट.
कंप्लीटिंग द यूनिट सर प्रोजेक्ट की बात नहीं करते, यूनिट की बात करते हैं. अगर
यूनिट
इफ
मींस
सम
यूनिट एंड यूनिट
आईटीसी
सर.
यूनिट का मतलब सर ये फ्लैट हो गया ना आपका, ये शॉप हो गया. They are not talking
Sir,
about the complete project.
no,
Ashish ji,
without obtaining CC or OC certificate, how can you go for registration or handovering the project or unit to the plot buyers or flat buyers?
But CC is not required for registration. OC is required.
Yes, OC is required. So, sir,
CC
if
is
the
not
OC is
required.
not there, and if they amend this regulation, whether if the home buyer demands for the registration of their unit, the RP, so it will be risk factor on the RP that he is.
नहीं सर, अगर OC है ही नहीं तो इवन इफ रेगुलेशन से तो रजिस्ट्री हो ही नहीं सकती. उसमें प्रॉब्लम कहाँ है?
yeah, Ashish ji, if property is registrable, suppose OC has been taken, then RP should also authorize his delegate to present before the registrar for registry. RP is not here to stand in the queue before the registrar. So here the amendment is required in this regulation that RP or his authorized representative. RP cannot
Right, sir. I agree.
wait in the queue.
Yes, yes, he's.
Sir, we are already doing that. 15 registries I have done last month by sending a representative. You can do that. It's
That
only
is your
regulation is
prerogative.
coming.
Yes.
You can
So
do
it is
that.
coming in regulation.
What
It's
is
very
not
good.
permitted, Devraj ji, what is not permitted under the law is prohibited as per the jurisprudence. So if we have done something out of the box, then IBBI will screw during the inspection. So we should have a specific authority.
But Ajay
Well,
ji,
specific authority
Ajay
can
ji,
be taken
Devraj,
under section 28 from the COC, and that is being taken, and then the registrations are done by the authorized persons.
Better it should be incorporated in the regulation. Why we should depend upon the COC?
राणा साहब आप कर तो रहे हो डेलीगेट करके, but delegation is not allowed for the RP.
No, sir.
Under section 28
Delegation
you
is
can do
not
it, sir.
allowed if we are doing something which is not permitted at all. This is a regular business of a CD where you are sending somebody just to. अभी जैसे किसी ने कहा था ना that we will not stand in the line. Just to save your one day, if you are sending somebody on your behalf to sign, I don't think it's a violation of anything. So I am doing it. I think I am ready to face. But yes, if it comes in regulations, I don't think it hurts. So it will be good for
Anytime,
What
IBBI,
is it? IP is core duty, you cannot delegate. Which IP has to do as an IP. This is a going concern business. So the regular registration, etc., was always being done by the company, and there are many IPs who take it as going concern business of the company and delegate it to the people who are competent to do that registration, because this is not core IP duty, this is going concern duty, so it could be delegated. That is the view taken by many IPs.
But
Agreed, sir.
it will be better if it is specifically incorporated in the regulation. So there will be more
100%, sir.
clarity.
Not to bring clarity and much help IPs in case of questions raised.
See, we should not only rely upon the practice which has been adopting. We should also have clear-cut clarification in the regulation itself.
Sir, as far as handing over of possession is concerned, so without obtaining OC and CC, in Mumbai at least, the possession itself we cannot hand over. So that itself is a violation of law,
No,
violation of
possession.
local laws. So as is where is condition, what this proposal is saying that you hand over as is where is.
No,
So
no,
that
Manojji,
is not at all possible.
Manojji, I am sorry to interrupt you. Here, possession coupled with the registered instrument. Without registry, there will not be transfer of title in favor of the allottees. So even if you give the possession, the possessee or the allottee will not have any title on the property without registration under Section 54 of the Transfer of Property Act.
नहीं sir, थोड़ा difference है. In liquidation, that will be a different scenario altogether. If it ends up into liquidation, the possession is as good as transfer of title. That will not be counted under your valuation.
We should not accept law as it is. Should be.
Sir, valuation regulations पढ़ लीजिए, वो भी यही कहता है कि possession units cannot be included in the liquidation estate. Even if they are not registered.
Any possession given without the title is a illegal possession.
Correct.
As per Transfer of Properties Act.
Correct.
This is very clear.
And I will cite the Supreme Court judgment, which was held in 2012.
Yes, that's why I am telling, being an advocate.
There is a change in the liquidation regulation which says that the
liquidation regulation cannot override.
Home buyers which has a possession cannot be included in the liquidation estate. This is an amendment in the liquidation regulations.
See, liquidation regulation.
I would like to make one thing very clear. Transfer of Property Act is a specific act related to properties only.
Correct.
So that cannot be overridden by any other act.
Correct. Section 54.
As far as the properties are concerned.
Sir, 238 apply नहीं करेगा?
नहीं, यहाँ पे जहाँ wherever ये टाइटल की बात आ जाती है ना, वहां पे फिर 238 अप्लाई नहीं होगा.
Okay. So, sir, how to conclude for this? So we are agreeing that RP should be given power to do the registry or the transfer of the ownership when the possession is given to the home buyer.
Yes, before giving the possession, there must be transfer of title. Without title, you cannot give the possession.
Correct. It should be, title can be done only by.
अगर सर बिल्डर ने पोजीशन पहले से ही दे रखा है आपको
तो आपको दिया है ना, आपको टाइटल किसी और को देने की पावर तो नहीं दी ना.
नहीं, बिल्डर ने अगर पोजीशन मान लीजिए प्लॉट बायर को, सॉरी फ्लैट बायर को पहले से दे रखा है, उसकी रजिस्ट्री ड्यू है केवल. इन दैट केस व्हाट विल यू डू?
Is in that case
whether that person should be included in CRP, number one.
In number of cases, builders had already given the possession.
His claim will be also filed. He has to file the claim. Without registration, he is not having any title. I'll just say the Section 54.
I think that we should speak one by one.
See, Section 54, sale. Sale is a transfer of ownership in exchange for price.
ठीक है अजय सर ठीक है okay, we agree with you.
चलो ठीक है. Thank you.
So Nini, you Ashish sir, see, this is a good thing, but it is coming with lots of ifs and buts. RP को थ्राइस कर रहे हैं ठीक है, लेकिन बहुत सारी चीजें और भी चाहिए.
देखिए पोजीशन पहले से ही है, तब भी ऐसो उसको रजिस्ट्री के थ्रू ट्रांसफर किया जा सकता है इफ लॉ परमिट्स, कि भाई अगर वो उसने सारे ओसी वगैरह ले लिया, सीसी ले लिया, देन ठीक है।
नहीं सर, रजिस्ट्री कैसे होगी? मान लो किसी अथॉरिटी का ड्यू है तो।
नहीं, वो तो दैट्स व्हाई आई एम टेलिंग कि अगर वो सारी क्लियरेंस ओके है, देन आरपी कैन गो फॉर रजिस्ट्रेशन।
So,
फिर तो
sir,
ऑल
we
इज
are
वेल हो गया,
agreeing.
फिर तो ऑल इज वेल हो
Sir,
गया सर।
sir, now at a message from the ICC IIP, we have to conclude this discussion. So we are concluding that this proposal should be agreed. This proposal should be agreed.
Yes, yes.
With addition of my points also.
Yes,
Yes.
I agree.
Thank you.
Agree, sir. Agree.
थैंक
So,
यू
ठीक
आशीष
है
सर।
sir. Thank you, sir. We are concluding this discussion, sir. Thank you very much for participation.
Thanks.
Thank you,
Thank you.
Thank you,
Thank you,
Ashish.
sir.
Thank you, everybody.
thank you, sir. Thank you.
Thank you.
Thank you, everyone, sir.
Thank you.
Anjali ma'am, you are there? Hello.
Thank you, everyone.
Yes, sir, I am here only.
Yes, ma'am. We are concluding now. Thank you.
Thank you.
Thank you very much, sir. Thank you all the participants for such a nice discussion.
Yes, ma'am. Thank
Now we have next session with Barsha ma'am on mediation issues related discussion.
I hope I'm audible and visible to all.
Ma'am, when we can start now. Now the session will be taken by Barsha ma'am on IBBI Discussion Paper dated 4th November on mediation by operational creditors before approaching Adjudicating Authority for filing Section 9 application. Let me briefly introduce Barsha ma'am. She is Commerce graduate and qualified PCS having 7 years of experience. She is presently working as partner in Vinod Kothari and Company and is engaged in corporate and resolution division of firm. She has been rendering end-to-end services with respect to insolvency and resolution services, corporate restructuring and litigation, and regularly appears before NCLT. She has been engaged extensively in resolution and liquidation matters as well as advisory under IBC and corporate restructuring. Now, ma'am, please start with the discussion.
Thank you so much, Anjali ma'am. So, hello and good evening to all. I hope I'm audible and visible to everyone.
Yeah.
Today's roundtable discussion on voluntary mediation by operational creditors under IRP SEPI regulation, which has been recently proposed by IBBI. So we will discuss around the proposal that has been placed by IBBI. So this session is expected to focus on the proposed amendment in this IRP CP regulations, whereby IBBI has proposed to introduce mediation as an optional mechanism for the operational creditors before they proceed with an application under Section 9 of IBC. We all know that there are 3 mechanisms as of now, that under Section 7, financial creditors can move with the application for initiation of CIRP proceeding, under Section 9, operational creditors, and under Section 10, the corporate debtor himself. So my role today as a moderator is to facilitate the discussion on the topic and collate the views of all the respective participants so that we can provide a collective and fruitful thought to be incorporated in the proposal. So I would request all the participants to be interactive during the session. So before starting this discussion on this particular topic, I would like to first give a brief introduction about the topic. So as we all know that IBC particularly is a time-bound process, and now it is becoming difficult to achieve this time boundness of the entire proceeding, mainly because of the lengthy proceeding which is pending before the adjudicating authorities these days. Mainly the applications are filed by operational creditors or financial creditors or third party under Section 60 subsection 5. So these lengthy proceedings are somehow creating hurdle in the path of achieving this time bound process. So it is very important to have to reduce the burden of judicial authorities such that additional mechanism can be introduced, some outside settlement kind of mechanism can be introduced so as to reduce the burden of the judicial system. As per IBBI's newsletter as on 30th September 24, if we see, majority of applications filed by operational creditors particularly have been concluded by way of settlement. Some 8,002 applications were admitted as on 30th September 2024, and majority of them were concluded by way of either withdrawal or by settlement. Majority of these applications pertaining to operational creditors I'm talking about. It has also been noted that settlement rate of CIRP pre-admission has been larger than any other stages. Such resolved disputes comprise more than 68% of the total disposable cases of NCLT. So to improve this efficacy, at this end, IBBI has now proposed with introduction of this mediation process. This was under the chairmanship of Dr. T.K. Vishwanathan that the committee was formed to find out as to how this framework for mediation can be implemented in the current IBC regime. And there were several discussion on the prospect as to what can be the correct measure for the initiation of mediation process before filing of this application by operational creditors particularly. I'll just share the discussion paper. I believe that all of us must have seen the two-liner discussion paper, the proposal that has been given. As currently this proposal provides for optional mechanism. It is an option given to the operational creditors to, before filing the application under Section 9, to opt for the mediation. But the question here arises as to whether this option is not available otherwise. Because otherwise as well, if at all it was possible for the operational creditors to go for any kind of amicable solution or amicable discussion with the corporate debtor, then I believe that all the operational creditors, rather than filing the application and incurring expenses from their own pocket, would have chosen to go for this discussion only and for this settlement only. So not sure as to how far this the ultimate objective for introducing this mechanism will give fruits, because this is, as of now, this particular mechanism is optional only. It's not mandatory. So if we are talking about mediation, so mediation, I believe that everyone of all of us must be aware that this is one of the additional mechanism or alternate mechanism for dispute resolution, which uses a neutral third party to facilitate the negotiation, settlement of the disputes and resolve the conflict between two parties. Typically, this mediation process is initiated either by mutual consent of the parties or by pre-agreed contractual clauses or by reference of any court or tribunal or by a mandatory requirement under the law. So this concept of mediation is not new, perhaps, because this particular concept of mediation has already been explored in India in other statutes in India. For instance, in Industrial Dispute Act, in RERA, in MSMED Act, in Companies Act as well, in Commercial Courts Act, Consumer Protection Act, etc. But this particular mechanism was not there and is not there in IBC as of now. In the meantime, this Mediation Act 2023 has also been enacted, which has been introduced on 14th of September. This provides a holistic approach, umbrella approach, one can say, that includes the eligibility of mediator, mediation proceeding, online mediation, enforcement of mediation settlement agreement, list of matters that can be referred to the mediator and matters that cannot be referred to the mediator. So this wholesome thing is there, but it is an umbrella legislation and can be opted in any kind of proceeding, including IBC. So nothing particularly regarding the code is mentioned as of now in this Mediation Act 2023. So this does not refer to IBC. This does not include this IBC within its regime, inclusive list or exclusive list. So it is not particularly provided as of now. But we know that code itself is a combination of various provisions. So, and its wholesome procedure which is provided, which is divided basically into two parts. One is CIRP, other one is liquidation. In between, now we are thinking of introducing this mediation. So how this proceeding will be initiated? What will be the timeline to conclusion of the mediation? What will be the cost of mediation? Who will bear the cost of the mediation? What timeline will be there? What procedures to be followed? Because for a particular, in general mediation, there's a process which is provided otherwise as well. And we can also refer to Mediation Act for that. But whether the same procedure is to be followed in IBC as well, how bounding this particular mediation settlement agreement will be in particularly in IBC cases. Say suppose if we are introducing this mediation as alternative in IBC regime, but if we are not making this mediation settlement agreement bounding on all the authorities, then how effective it will be. So there are several concerns which are still there, which are not yet resolved with the proposal currently, because proposal currently, if I'll just show, is a 2-liner proposal. I'll just share my screen. Just allow me a second.
Ma'am, if mediation is between two parties, which are one is OC, why do you need authorities to be party to this? You just said that how binding it will be on authorities.
I'm sorry, sir. Can you please just repeat again?
I'm saying if we have, so this mediation is being mandatory for the Section 9 application, which is the OC.
It is not
right?
mandatory, sir. That was the
No,
concern. It is
that's what
not
I'm saying. So
mandatory.
it's not mandatory, but you were
Yes.
saying that how binding it will be on the authorities. Why do we need it to be binding on authorities? It just needs to be binding between the two parties who are part of the parties to the mediation. So as
Even
long
if
as it is binding, it will serve the purpose.
So it is not, again, that, sir, that mediation will be binding on the respective parties as well, because that is also not provided as to whether at all this mediation settlement agreement, the so-called mediation settlement agreement, will be binding on the party. Because say suppose if two parties have come to the amicable settlement and later on they decide that no, they don't want to proceed ahead with the settlement, that they have arrived otherwise, then again the window of filing this application under Section 9 is there. So again, this forum will be explored further to go ahead with this
Correct, ma'am.
application
That
under Section
option
9.
is always there in every other law also. Even in
Yes.
district courts, if mediation fails, you always have a option of coming back. So mediation is an option which you want to try. That's all. And I think it's a very welcome move. Only thing is that you say, kill some time unnecessarily. Uh, but I think it should be a welcome.
Otherwise as well, sir, my question here is whether this option otherwise what not available to the respective parties, to the operational creditors and corporate debtor otherwise. If say suppose this particular provision was not introduced in the IRP CP regime, are we saying that this particular option to opt for mediation was not available otherwise to the corporate debtor and operational creditors?
Madam,
Amicable settlement is always available to people. I mean, if they wish to. You are absolutely right. Who stops two people from talking their differences out, right?
That is what she's telling.
That is the whole concern here, sir, that as of now,
Madam, this is a fantastic point that the option was always available, and when the option has not worked, they have come to the case. They have to increase the strength of entire judiciary, not just NCLT, by quantum leap of 50 to 100 times. 2-4 times won't work, because implementation of every law has failed. We have new laws coming and new tribunals coming. If original law was working fine, we wouldn't have even required IBC or any other prior law. If what is failing, we keep on doing that. And even in Commercial Disputes Act, the success rate is less than 2%. What is required to be done is not being done, and what is failing is being kept on being done. And even the committee which IBC, the committee which was put up for mediation in IBC, did not have the mandate to say whether they have to bring in mediation or not. The mandate was how to bring mediation. So we are bringing mediation. You tell us how to bring mediation. Whether mediation has to be brought or not was not given to those experts. And we are keep on doing failing, which is making laws after laws. What is required is implementation. What is required is judiciary. And if we don't increase the strength of judiciary and judicial infrastructure by quantum leap, we will soon become banana republic. The disposal rate at Honorable Supreme Court as was reported by press, it will take 300 years to dispose of the existing rate. If it is going to take 300 years, then which criminal or fraudster is going to be afraid of law? You go to court, even my grandson won't be alive by the time the case is disposed of. I will appeal in Supreme Court. So what we require is increase of judicial strength, increase of judiciary by a quantum leap. Making these laws is not going to help. This is my humble understanding. I'm not putting any further point during the discussion because this is a wrong step and wrong direction which we are taking. It is forced by some experts in the government. Neither the bankers need that, nor operational creditors, nor insolvency professionals, but it is forced by government or some bodies of government or some interested people, conflict of interest. They have forced government with some influence to bring in this. This is my understanding and I'm point blank clear on this.
I would like to invite comments of others as well as to what they think about this proposal that has been introduced by IBBI with respect to exploring mediation before filing the application under Section 9 as an option and not making it mandatory at this stage. Mr. Vishwajit Gupta, if you want to say anything. Yes.
Madam, I'm Prabhat.
If anyone has any particular comment regarding that as to whether this proposal or what is the efficacy of this particular proposal that has been proposed currently by IBBI.
Madam, I am Prabhat Jain. I am allowed to speak.
Yes, sir, please.
Madam, the feelings are same. No operational creditor have tried everything. Nothing works. Then only he is choosing the route of NCLT or IBC. I personally applied on behalf of OC in 3 cases, and all 3 cases, the CD settled the same after 2 years and 3 years only when the case was about to admit it. In one case, CD never appeared in the court, and the matter kind of 7 times it has been heard, public notices issued, and just before the admission, CD paid at the night of the first night before the admission. So mediation, everything has been tried by the OC. Now, why this amendment or why this provision is coming? My understanding is that NCLT don't want to discuss on these things. NCLT feels if something can be settled outside the court, then it has to be. But there is no any law which forces to the CD to pay on priority. The IBC is the simplest, fastest, easiest, and quickest law which forces the CD to pay on early basis. This is the only reason. That's why OC or any creditor is coming to IBC and not to the civil court, not to the any other law. This is my understanding, and I feel the same till now.
I agree with your understanding, sir. In fact, the thing is that, like, if we give options to the operational creditor to either to go for the lengthy settlement, which may or may not arrive at, and the other option is to go for the NCLT and get the conclusion with the with the money back by way of settlement or something. So obviously, operational creditor will choose the second option only. They will find it better to go or to move to NCLT with an application, and the regular practice that as a practitioner we have seen is that only that the process that operational creditors opt for is they use this IBC as a recovery mechanism, whereas ideally the whole idea for introducing IBC was that IBC should not be used as a recovery mechanism, but for operational creditors there is nothing else survives, because they know that there is nothing else that they will, even if the assets will be realized, they will hardly get anything. So the idea of realizing anything for the operational creditors is very low. On the other hand, they have to incur expenses from their pocket to file the application, to meet the expenses, the litigation cost, etc. from their own pocket. And then the idea is always to have the settlement done before the admission of the application, because they know that none of the corporate debt or none of the companies will intend to start the CRP proceeding against them. So they will always want to settle this particular operational creditors, because once the process is admitted, then there will be a pool of creditor. and consent of this pool of creditor, 90% of this pool of creditor will be required for this withdrawal of this CRP proceeding. However, till this admission stage, only one creditor is there, the applicant, and by settling that particular applicant, the corporate debtor will be free from CRP and the process will not move further. So they have opted this IBC regime as a recovery mechanism to get their money recovered. If you see particularly the cases of operational creditors. So we can say on that line only that this option particularly to opt for settlement was always there and is always there for all the creditors, including operational creditors. So it is not that this particular option is not there for them to go for the mediation. It is only because that they know that mediation or the settlement is otherwise is not possible. The other party, the other creditor is not ready to come to a settlement at an amicable solution to the dispute between them. And that is why they are bound to go to the NCLT, incur expenses from their own pocket and get the proceedings started. So this is the main concern when it comes to operational creditors application. So currently, if we see the expert committee's report, the report that was submitted by the expert committee formed by the IBBI, there were several recommendations provided therein. However, as of now, only a part has been introduced, that too on voluntary basis, because nothing specific has been provided to keep this practice of introducing mediation in line with what is provided in IBC. So nothing particular there is provided as of now. It just says that it's a voluntary process. Operational creditors may opt for the same. And if the operational creditors are opting for the same, then the report of mediator is required to be submitted along with the applications that that they will file if this settlement is not arriving at. So at that position, if say suppose the settlement is not arriving at, then they can file the application under Section 9 along with the report of mediator. So this is what is required. And for the proceeding to be followed, only the Mediation Act 2023 has been referred. So one has to refer to the Mediation Act 2023 as a whole. But whether any carve out particularly should be there, whether any particular exclusion should be there, whether a timeline should be provided, whether cost as to who will bear the cost, whether both the parties will bear the cost, whether the CD will bear the cost, and what will be the mechanism to be followed, whether there will be a particular panel of mediator to be established along with the NCLT to look after this entire proceeding or not, who will be acted as mediator, whether the mediator list of mediator which is provided in Mediation Act particularly will be mediator for this matter as only, or any person who has expertise in IBC regime should act as a mediator. So these things still require clarity. So these clarities are still not there or still not provided in the provision as of now. So the other question that I would like to raise at this point of time before this forum is, what will be the possible cost implication and its impact on operational creditors' decision if they decide to opt for mediation?
Ma'am, myself, Sandeep Mahajan, I just would like to add, this is a welcome step coming mediation to IBC. The only thing is that it should be made mandatory. Only then it will be more workable. I mean, otherwise it's a voluntary. Even now it is a voluntary. I mean, you and me, if we have a difference, we can always decide to settle or you may not decide. If it is made mandatory, only then the CD will come to the table to discuss with the OC. Otherwise, it may not happen if it is made voluntary. Coming to the cost obviously will be, as you put the second point, it will be much lesser and it will be cost effective, time effective, and it helps everyone. I mean, the judiciary. One of our members said that we should have more members, but let's understand the limitation of the country in terms of the judiciary. They have lakhs and lakhs and crores of cases. It can't go on like that. So mediation, I think it's a welcome step. The only thing is that in IBC, it should be made mandatory. And many queries you put up, who will be the mediator, that can always be taken up by the Mediation Council of India, which is proposed to be set up. And they should have, like in IBC, need a certain expertise. I mean, anybody can't do mediation. So I think the RPs or the IPs who are registered with IBBI, they should be the panel should be set up among them, and they should be given the role of mediator. That's my view.
The next question that I would like to place before this forum is the proposal, as we all know about mediation under Mediation Act, is currently optional, is currently not mandatory. So what could be the possible difficulty that you see before operational creditor, where the operational creditor's sole interest lies in getting money only? So what you all feel as to what will be the possible difficulties will be in front of the operational creditors if they opt for this mediation rather than going for Section 9 application at the initial stage itself?
Madam,
Madam,
this should be considered as a dispute, and then if he later goes on for Section 9 application, it will be taken as a dispute and not proceeded further. Maybe even if government decides for policy reasons temporarily to go for this, some protection for that has to be there. That how it will not be considered as a dispute. And then maybe if you are asking for operational creditor, that is the only point which I raise at this point.
Madam, I am Prabhat.
Can I
Yes.
speak? Hello,
Madam, say that if optional is there, then operational creditor decide to go for mediation. Then first the preparation, the cost and time will go. And operational creditor having the simple demand that clear my dues, and the creditor doesn't agree, then again he has to incur the same cost, kind of another set of preparation and submission for the Section 9. There is no consideration of this substantial time which is going planned to go into the mediation. Then again there will be a new discussion, new argument in the Section 9 application, and then there will be an admission. Otherwise, that could be a set of kind of summary short procedure that these are the discussion, the failure of the mediation process and application to the Section 9, and it will get admitted in first hearing or second hearing. Otherwise, we cannot compensate the time, right? We can compensate the cost, but we cannot compensate the time, and that's why it will fail. Or the creditor, why they should go for mediation? Because there is no absolute guarantee or no absolute saving of time. If this saving of time can be attached in mediation process, then people may feel to go good for mediation. This is my submission only.
I absolutely agree with this particular point of yours, sir, that the money can be compensated, but time, of course, cannot be compensated. So the time that they will involve in this entire mediation process, they will not get the time back. And they have to start the entire Section 9 proceeding afresh if the mediation does not work at the end. So this particular observation is absolutely, in fact, I am also in line with this particular observation that if mediation does not work in that case, the time of the operational creditor is definitely getting compromised. So if
Second point, madam.
Any
To this point, sorry. In mediation, generally the time given is very less. It is not years and years. I think even the Act says 90 days or whatever. So it is not, and our application before NCLT take years. So even if we give a chance to mediation, maximum it will take maybe 2, 3, 4 hearings. It can be sorted whether the other person is interested or not in settling it. I don't think time should be a major issue.
The concern again here is as of now, the mediation has been proposed at the early stage only. Like before filing the application, you can opt for mediation, or it's better to opt for mediation. And if mediation is not arriving, in that case, go for Section 9 application. But mediation is such a thing that can be opted at any stage. In fact, if we see the IBBI expert committee's recommendation as well, they have also proposed or recommended the stage-wise implementation of this mediation thing. And they have also proposed this that before starting of the process, during the process, and in fact, towards the liquidation as well, if this mediation thing can be achieved. So somehow the idea behind the same is to reduce the burden of NCLT, because as we know that till the time the CP-IB number is registered with the NCLT, the persons connected to the application and otherwise as well, the third parties are also welcomed to file the application before the NCLT connected to the corporate debtors matter. So several applications in one particular matter we all have seen that are filed before the NCLT, and NCLT is unnecessarily burdened with so many of applications. So if it is better to to first mitigate the dispute at the very prelim stage, it's better. But at the subsequent stage as well, if there is a possibility to mitigate the disputes by way of mediation, then that process should also be introduced, but which is currently not there. I believe that IBBI, as and when, or based on the practice, based on the experience as to how this mediation is working, will certainly provide the detailed framework as well, and will provide respective changes as to how to introduce this mediation in several other aspects as well. So that also, I believe that that will be introduced at a later part by IBBI regarding this mediation, introduction of mediation basically. Because regarding qualification of mediation as well, if we see that as of now, this Mediation Act provides for a particular qualification for the mediators. But as I said, that this is an umbrella legislation. This is for all kind of proceeding, all kind of litigation. But you cannot expect from a particular person that the person will have the entire knowledge about the IBC. So until unless the person has the knowledge about IBC, how can that person act as a mediator? Because role of mediator or the mediation process is also 4 types. There are 4 types of mediation process, which is also discussed in this IBBI's report, that the 4 types of mediation is facilitative, evaluative, court mandated, and transformative. So this facilitative thing is that this is mere facilitation. So here the role of mediator is very limited. Mediator's job is to assist the parties in their negotiation without expressing their views. So here the mediator do not have the right to express their views. On the other side, the evaluative process, wherein this evaluative process is sector-specific knowledge. So mediator has a sector-specific knowledge in this particular model to assist the parties by assessing the merits and demerits of their case as per the given legal position. Court mandated is where court particularly mandate that go for mediation rather than continuing hearing, try for the mediation first. So this mediation is directed by the court in the interest of the parties by promoting a speedy and cost-efficient outcome. And the last one is transformative, that places particular emphasis on 2 key interpersonal process. One is empowerment and other one is recognition. In addition to working to enable parties to recognize each other's position, the mediator seeks to empower parties to make their own decision. So these 4 types of mediation process are also discussed in the recommendation by the committee. But in detail, if you see, the proposal does not entertain all these factors or this type of mediation as of now in detail. So that concern still needs to be addressed as to who should act as a mediator when it comes to IBC process. Whether the mediator should be a person having expertise in the IBC or any person can act as a mediator. So I would like to invite thought on this particular question or concern as well from the panel here as to what they think about the qualification or eligibility of the mediator, particularly when it comes to IBC.
Only IPs, where the expertise to understand.
I have an absolute reverse view. Every work should be
And the
left
point
to a
is,
domain
even if you
expert.
put IP
So it should
as
be
a
left to
mediator,
experts in mediation. If an IP is also a mediator and expert in mediator, no problem. But the qualification should be expertise in mediation and not insolvency professional. That is my humble view. And my second view is, at the beginning, the people have very high egos on both sides. And within 2 or 3 months to bring down the ego and bring down something is something very difficult. I don't think so. Even an expert mediator could do that, although I'm not a mediator and not would act as also as a mediator. So I have no conflict of interest in saying so. But my feeling is it should be left to the experts if at all it is brought in. And second thing is it is difficult to succeed.
Any other thoughts on this?
Madam, see, if some disputes are there, then only we need this kind of some expertise. And as we are mentioning that there are multiple types of mediation process, right? So first we should be analyzing the cases which are having the multiple types, or the problems could be multiple types. Take an example of salaries has not been paid from last 2 years. Now what the mediation is requesting? Say I have supplied the goods 3 years ago. No any problem. Still the dues are outstanding. So what type of mediation is requested? So the really answer to your question, first we should have a category, then we should be attaching the expertise, or the qualification. Third, we should have some qualification or relevant knowledge of IBC, because if mediation fails, say the patient is not able to get the benefit in OPD, then he has to go for surgery. So the person is doing the mediation should have some knowledge of IBC. The mediation fails, then you have to go for the process of IBC. He can give the example or the possible scenarios. This much of time will take, this much of hearing will take place, and this much of evidences or the penalties can be imposed. So combination of both will be requested. Nothing could be a particular qualification, because the empathy, communication, and the expertise to a subject only is requested. This is my submission.
Any other thoughts on this? Okay, so I'm coming on the next concern, which is about the process to be followed for mediation. So as of now, the typical process that has been followed for the mediation is reference of dispute to the mediation, then identification of a mediator by court or by authority, then mediation proceedings, then opening session, then written notes, then one-on-one discussion, then joint discussion, and at the end, closing session. So this is the typical process which has been followed when it comes to mediation. But as of now, since the proposal directly refers to Mediation Act only, so whether we think that any particular process to be followed for the IBC only should be provided, or the process which in general is provided for all the provisions under Mediation Act will suffice. If anybody wants to have a discussion on this particular part as to what they think about the process to be followed during IBC as mediation, so may also discuss regarding that. May also share their view regarding the this particular process to be followed during IBC for mediation.
Ma'am, I have a one submission. The timeline should be fixed for the same, because unnecessary timeline could not be enlarged for in name of mediation. So 1 month, 2 months, 3 months, whatever the timeline, that should be fixed up, within which, if the mediation is failed, then ultimately that the parties authorized to file an application before the NCLT.
Any other thoughts on this?
Yes, maybe the same person who is being the mediator. I don't know if we can put that this same person may be appointed as IRP, because this person is already aware of what the CD is doing. It may help in taking over the company, etc. So
I
same
absolutely
person
oppose
might
this.
be allowed.
There is a clear conflict of interest. The person who is mediating can never act in IRP or RP. There is a clear conflict of interest over here. In success of mediation or IRP, I am sorry to my colleague friend, but this should never happen. First of all, if I go to the sequence, there should be no mediation. If there is any mediation, it should go only to expert mediator. And even if IP and mediator both are taken, mediator
Opinions are opinions. Sir, this is opinion. No, it's not emotional. Just an opinion. You can put your opinion also. No problem.
Decide. From my side also, it's an opinion only, sir.
Madam, I am Prabhat. Madam, I am Prabhat.
Yes,
Am I allowed to say something?
hello.
Yes, madam. We
Yes.
are discussing the kind of format and the procedure should be adopted, right? So
Yes.
I would say, if I am OC and I am going for mediation, then my preparation should be kind of in line with the IBC, because the same set of preparation of documents which can be presented to the mediation and same can be used for IBC. I should not be preparing the different documents. And for mediation, when it is not where it is optional and it is not mandatory by nature or by the end result, then I should not be focusing on the process. It should be based on the verbal discussion and the submission of the documents. There should not be a structured set of documents. Otherwise, we will be spending 15 days paying hefty amount to the consultant to prepare the set of documents. See, issues is being discussed between two parties who are not able to pay, who are not able to receive, who are having some dispute. So both the parties knows the issues very well. Why we are trying to tell them to put on the paper everything? Then only the mediator will decide. Mediator is not here to decide. Mediator is there to say, good, you do the discussion. Very good, come on Monday morning, come on Monday evening, come on tomorrow evening, do some settlement. You are charging interest 10%, try to make it 9%. I am not able to understand till now. I have not gone through any mediation process, so I am not having good knowledge of mediation. But my feeling as an OC, I would like to discuss on the table once, twice, and thrice. Not doing the preparation for mediator. The mediator is not going to read the case and decide. Me and the creditor both are going to discuss and decide. That's all. This is my submission.
The whole concern is revolving around this concern only, sir, that since the settlement otherwise is not possible, and that is why the operational creditors process, if you see, that also requires to send demand. And then after sending this demand notice, if that demand notice is not getting the conclusive response from the respective corporate debtor, in that case, proceed ahead with the application under Section 9. So the idea is that only that otherwise the settlement is not possible. Like if two parties are unable to sit on the table and discuss or decide the matter between them, then what they can do is they can ask a third party, an independent third party, to act as a mediator between them so that they can individually discuss their concern as to what concern exactly is there. And after this mutual discussion, they can arrive on certain points with amicable solution to resolve the dispute. So the whole idea herein is to introduce just to reduce the burden of NCLT so that this whole lot of application which otherwise are pending before the NCLT to resolve, NCLT can be freed from this kind of application which are otherwise, we know that will lead to settlement only. So if otherwise by filing an application before NCLT, you are thinking of going for settlement, so it's better to go for the settlement beforehand rather than wasting NCLT's time or rather than taking NCLT. So
I have one more suggestion here. In NCLT, whenever Section 9 applications are there, many a times the dates are getting in, people are getting dates just on the premise that settlement talks are going on. Those applications, if sent to mediation, we can understand. Sending every application mandatorily for mediation seems little far-fetched for, I don't know. That's the view. Another view I have. Wherever any party says that yes, we are, in settlement talks, which normally happens in Section 9, those let them go to mediation. How the district court also sending. But wherever when they are not even on talking terms, when they are not even responding to the notices, sending them for a 3-month spree will not add anything. And see, IBC came into picture when we said that first instance of stress, it should be admitted. So when we are saying first instance of stress, it should be admitted. Why do we want to spare another 4, 5, 6 months on mediation, and then the company will be even under more stress after 6 months? There is no interim moratorium. People will be aware. CD will be aware that yes, I'm getting this problem. I think
sorry,
that's
I'm just
another
intervening
view.
here that the timeline which currently is provided in Mediation Act is of 60 days, not 7, 8 months, not like that. It's 60 days as of now. But surely this 60 days timeline cannot work when it comes to IBC because IBC process is again, you have to complete the process within the given timeline which is provided. So you cannot take this 60 days timeline merely to think about whether at all the settlement is possible.
When we know what 14 days admission timeline means, right? So 60 days will also mean something similar. That's why. So anybody saying, any OC saying we are in settlement talks, let them go to mediation and come back. Till then, let the court not be burdened.
So
But
again,
if
to
there is,
implement this,
that,
unless there is any enforcement mechanism for this mediation outcome, do you think that this process will give any kind of fruits if enforcement mechanism is not there, till the time the enforcement mechanism is not there? Because party will waste time, party will say that the settlement is going on, and after that again they will file section 9 application, then again they will say that no, we are thinking of settlement. So there has to be some kind of restrictions, some kind of enforcement mechanism there that will imbibe the party, or that will restrict the party from making this frivolous submission before the NCLT and taking it seriously when it comes to, when they say that they are opting for mediation, or they want to settle the matter.
Madam, this suggestion is again what is happening since last 40 years. We are making more laws because the original law is failing. We had IDDB Act, we brought surfaces, we brought criminalization of check bounce under Negotiable Instrument Act. Everything is failing because we don't have the infrastructure. Then we are bringing mediation. Then they say games will be played in mediation. Then we bring another law. So what are we doing? Are we just enriching the lawyers? Or are we delivering justice? It's a serious question. Is the nation just to enrich the laws and professionals like me? No. It is for delivering justice. We need to increase the strength of judiciary. We need to increase judicial infrastructure. And if we are trying to avoid that and looking in other way, we are creating disaster for our future generations. We are running away from the reality. We are shying away from the reality. We need to face the reality, and we need to tell the government, this is your job to bring infrastructure. Please bring the infrastructure. Don't try what is failing since last 40 years. Furthermore, this is exactly within 1 hour or also 40 minutes. We are saying something. If mediation fails, we bring another law. What is this we are doing?
Ma'am, I think your query was about the process to be followed over here.
Yes.
Madam,
I think the process which you have suggested, as in the Mediation Act, it is a fair process, being the opening statement, joint discussion, single discussion, and closing statement, whatever. I think the process, whatever, I think this is what I think you meant by the process, and you elaborated on the process. I think the fair process that should be followed over here also.
Madam, I just want to submit one thing.
Yes.
That entire this process of mediation process, or what the language of the document, it is saying the OC has to go for mediation. But madam, we should focus on the word. OC is suffering. We should use the word, the CD should go for mediation. CD should do the arrangement. CD should call to the OC for mediation. Madam, entire the burden we are shifting on the OC just by putting everywhere OC, OC, OC. So this is kind of not bringing good vibes. Here CD should be applicable. I want to recover my money, whether it is good for CD, it is bad for CD, it is CD is suitable for resolution, or whatever it is. Why a OC should have all this knowledge? CD should have all this knowledge, that he should allow OC for go to IBC and bring the resolution by IBC, or he should be ready for mediation. The entire the document, it is forcing this OC, that OC is a culprit. OC is not a culprit, madam, it is sufferer. Again, he is going to suffer more by this process. And we are happy with all the process, which can deliver a kind of certain guarantee and immediate and the time-saving manner. OC is ready to do everything. This is the kind of answer or the summary of all of the discussion.
So with the discussion that we have as of now, the ultimate conclusion that we can derive is that only, that until unless we will have the entire framework before us as to what to follow, how to follow, the entire procedure as to what exactly has been proposed, it will be difficult to implement the same as at this stage, because the option is still there. The option is still there for the operational creditors and other creditors, and of course for the corporate debtor as well, to settle the matter out of the court rather than approaching the court and starting the adjudication proceedings. So this option is still there. So until unless the entire mechanism is not clear, the entire process to be followed, who will act as a mediator, what will be the timeline to follow the same, who will bear the cost for mediation, what will be the enforcement mechanism for the same, until unless these details are there on or incorporated by the IBBI, till then it will, we feel that it will be difficult to implement the process or implement the, or to achieve the actual outcome which otherwise has been has been thought by IBBI to achieve by introducing this mediation mechanism in IBC or IRP-CP regulation as of now. This is the concluding thoughts on this. Based on this, we will conclude today's discussion. Thank you all for the participation, and we will incorporate necessary changes. We will provide the necessary proposal. With the discussion that we have today, we will provide those, we will imbibe those thoughts in the document and provide the same to ICSI IIP to incorporate. And
Madam, please also include the views that infrastructure has to be increased. If
yes,
it's an alternative, please include that. And we are not here to enrich professionals and lawyers. We are not here to enrich insolvency professionals and lawyers. We are here to do what is there in interest of nation, what is in interest of economy. And this is seriously against the interest of economy, but it is enriching professionals like me and you, which is not to be done.
Thank you. Thank you so much, everyone, for participation. Thank you.
Thank you very much, ma'am, for such a nice discussion on the topic. Thank you all the participants for sharing your views with us. Ma'am, please share the comments to us so that we can forward it to IBBI also.
Thank you, Anjali ma'am, for the opportunity given to me. Thank you, everyone.
Thank you, madam.